And the first thing I want to do is remind you guys, for those of you that are interested, Winston-Salem Home Builders Fall Parade of Homes is this weekend and next weekend. So if you are in the area, or if you will be in the area, I encourage you to check it out. That just, you don't have to go to all of them, of course. If you want to, you're welcome to. But if you just want to go check out a couple new construction homes, a couple parade homes, here's your website. I'll be happy to put it back in the chat. But it gives you like the what homes are available, the addresses, that kind of thing. It even gives you a map and shows you what homes are on the map. So if you want to plan your route, you can use this guide to help you do that. Anybody planning on going? I'm just curious if you think you might stop by and check out something. A few of you? Good, good. We may ask you to check in on Tuesday if you would like to share with us about your experience. Obviously not required. I just really think it's a good opportunity for you guys, especially as we're trying to learn and see what it is. It's your real world piece of it. Do you have any questions on the Parade of Homes? Okay. We are in the throes of Unit 9. Remember, Unit 9 is our basic contract law. Unit 9, you guys, first year law students spend an entire semester in an extended version of Unit 9. So, in understanding contract law, we need to understand the terminology, and that's what we're doing in Unit 9. You and I are not in law school, and we're not here to be lawyers. However, we deal with contracts on the day to day basis. You and I are responsible for the contracts that the buyer and seller uses to legally bind themselves. We're also involved in those agency agreements. So we need an understanding the ins and outs of the contract. And that's what Unit 9 is about. So we left each other, and it's so important that we see and understand the difference between the statute of frauds and the Connor Act. We met the Connor Act back in Unit 5. I do encourage you to write these two down side by side so you can see the difference. The Connor Act in Unit 5 told us that there were certain documents that have to be recorded. And the whole reason these documents have to be recorded is so that they're enforceable. Then we introduced you to the statute of frauds. And the statute of frauds typically runs parallel with the Connor Act. I can't record a document if it's not valid. To be valid, it needs to be in writing. So the statute of fraud says, well, you can't record it until it's writing and signed. So the two of them run parallel. Both of their purposes is to help validate documents, help with their validity, help ensure that we're not committing fraud or forgery or anything like that. Connor says you have to record. Statute of fraud says it has to be in writing and signed, both for the purpose to be enforceable. Do I have any questions on the differences? It's small, but there is a difference that we need to be aware of. And again, I think a side-by-side comparison in your notebook will help you see that. Any questions on Connor or the statute of frauds? Another contract term we need to be familiar with, and this does come up quite a bit, not just for our purposes, but even in the real world, is something called the parole evidence rule. And what the parole evidence rule says is that the final written word of the contract shall prevail. Any previous negotiations, any previous advertisements. Basically, what we're saying here, you guys, is if the negotiated item, the negotiated term, does not make it into the final sales contract, then it doesn't count. So we can advertise, we can negotiate, But if it doesn't make it into the final sales contract, it doesn't count. That sales contract is the final word. Let's use an example of that refrigerator. We all know the refrigerator is personal property, which means it's a negotiable item, and it's probably the number one negotiable item. It's going to come up. So you're a listing agent and you're at this listing appointment, you're talking to the seller, and you say, most buyers will ask for the refrigerator. Are you willing to leave it with an acceptable offer? Many sellers will say yes, yes, I can leave the fridge. Not all, but some sellers, most sellers will decide to leave the fridge. We put the listing into MLS, and I even advertise, I promote seller to leave refrigerator with acceptable offer. Buyer comes along, they're interested, they look at their agent and they say, I get the fridge, right? And their agent says, well, yeah, it says right here in MLS, you get the fridge. Buyer says, well, I need to find out for sure. Call the listing agent. The listing agent says, absolutely. With an acceptable offer, the fridge is yours. Buyer makes the offer to seller. Fridge is in the offer. Everybody is in agreement. Everybody is on board that the seller's going to leave the fridge. But guess what? The fridge doesn't make it as an exception to personal property in the sales contract. My question to you, it's not in the contract, parole evidence rule, is the seller contractually obligated to leave the fridge? We've agreed on it, we've advertised it, but it didn't make it to the contract. Shake your head. Do they have to leave the fridge? Nah, they can take that refrigerator, because if it doesn't make it to the final sales contract, it doesn't count. So in the real world, you guys, this comes up a lot. We negotiate, we've agreed to terms in an email, or we've agreed to terms in a text, but those terms don't make it to the sales contract. So it doesn't count. Everybody good with this? It's got to make it to the contract. All points of negotiations have to make it to the contract in order to count. And that comes from the parole evidence rule. Another contract term is something called time is of the essence. This is a drop dead date and time. This says some performance is required to happen by this certain date and time. There's something you have to do by this date, this time, very specific. And if you do not do it by then, you could be in breach. Time is of the essence is a drop dead date and time. We actually have two time is of the essences when we look at our sales contract in Unit 10. We will see this verbiage in our sales contract. Time is of the essence. We'll see some examples then. Right now, we're just understanding the basic terminology. We agree for this date and time. If it doesn't happen by then, the party that did not perform is in breach. And any good sales contract is going to have remedies for breach. What happens if one party breaches? The contract will spell it out. You guys do me a favor and set your chats to private. I got a question for you guys. In a private chat, one word answer. In Unit 5, we introduced you to the word amendment. Remind me in the chat what an amendment is. What does an amendment do? If you're amending something. Specifically, we talked about zoning amendments. What were we doing with the zoning amendment? So an amendment, you guys keep this simple. An amendment is a change. If you amend something, you change it. In zoning, we talked about a zoning amendment. So what were we trying to do? We were trying to change the zoning. Maybe it was residential and we were trying to change it to mixed use with residential and commercial. In contract world, once we've already agreed to terms, we are under contract. The parties have negotiated, agreed, and signed. Congratulations, we are under contract. We can go into, I call it round 2 of negotiations. We can go into negotiations for repairs, maybe a reduced purchase price, whatever. Anything is negotiable, literally, y'all, up until the time it closes. So things can and often change. And anytime we change something in the contract, we amend it. Now, I want you guys to compare that word amendment to the word addenda. When you see the word addenda, I don't want you to see the whole word. What I really want you to see is the word add. If we're using an addenda, it adds to and becomes part of the agreement. So an amendment is used to make a change to something we've already agreed to. An addenda is used to add to it. It adds to the offer. It almost enhances it. All transactions are different. You're never going to do a transaction like you had done before. Consider this. Every single property, every seller, and every buyer are different. And the unique combination of those three brings us a different transaction every single time. Most transactions require some sort of addenda. They require additional paperwork specific to an additional addendum specific to this contract. We've already discussed one addenda. That addenda was our lead-based paint and hazard addenda. If the property was built prior to 1978, then we have to add the lead-based paint and hazard addenda to our offer to purchase and contract. We have several other addenda that we use. Well, we have a lot, but we have several that we use more frequently. We're going to talk about some more commonly used addenda when we get into next unit, unit 10. So things that add and upon agreement become part of the offer to purchase and contract. Again, with these two words, amendment and addenda, I think a side-by-side comparison in your notebook is very helpful. So you can see these differences. Keep it simple. An amendment changes, an addenda adds. Questions on this? An assignment, if you are assigning something, you're substituting the parties. With an assignment, all the terms stay the same. The only thing that changes is the names of one of the parties. The assignor is the giver of the assignment. The assignee is the receivee of the assignment. You may be able to assign your duties and responsibilities within the contract to another party. Whether or not you can assign your rights or duties to another party has got to be spelled out in the sales contract. It has to say if this is allowed in this agreement. Put our sales contract aside for a second. I think the biggest place that we see an assignment, or an example of where we see an assignment, my homeowners on the call. You may have talked to a lender to originate your loan to purchase your home. And there's a really good chance that at some point that lender sold your loan to another lender. That would be an assignment. All the terms stay the same. Your payment didn't change. Your interest rate didn't change. When it's due didn't change. All the terms stayed the same. The only thing that changed was the name of the lender. It was assigned from the lender that originated to the lender that's going to take over your loan. Next week, we start getting into our lender units. We're going to look at 14 and 15. We're even going to talk about why they may assign your loan, assign your debt to another lender. So we'll get more into that. Right now, again, we're just still defining words. That assignment is a substitution of the party. You're transferring all your rights and duties from one party to another. We may also have a novation. With a novation, we are substituting an old contract for a new contract. Maybe there's changes. Maybe there's a different party. But we've agreed with novation. See the word new. It's a big play on words, I know, but I would write that down. Novation equals new. We've substituted a new contract for an old contract. Once upon a time ago, before we had e-documents and e-signatures and the e-world that we're in today, we were negotiating on pen and paper. And we were actually like, negotiating the purchase price. And we would have to cross through this purchase price, write in the new purchase price, and everybody would have to initial and date that change. You do that enough times, things get hard to read. So the suggestion is once we've come to terms, once we've come to agreements, to do a novation. Substitute the contract that we can read for the one that we can't because of all the changes of all the negotiations that had happened. A real world example of a novation that I had a couple years ago. I was working with an investor, a flipper. So he came in, bought a property, flipped it, and then I put it on the market for him. And the buyer, we were on the market, and the buyer that came through was getting what's known as an FHA loan. More on that next week. So an FHA loan is a type of loan, and there are certain requirements. And one of those requirements was that the seller, the owner, has to have owned the property for 90 days in order for FHA to approve the buyer's loans. Now, usually this isn't a big deal, but when you're dealing with investors, they typically don't own the property for any longer than what they have to. So we attempted to go under contract. Y'all, my guy had owned it for 89 days. And the lender called and said they'll kick that back because they require 90. So we all hung out for 24 hours. We were patient. And then the next day on day 90, we did a novation. We substituted a new contract for the one that we signed yesterday so we could get that loan to go through. One daggum day. It is what it is. So a novation, again, see or write down that word new. Discharging of contracts or how contracts end. There has to be some kind of end. So we got a couple different things going on here to end or discharge the contract. Full performance. This is what we shoot for. This is what we go for. Once the terms of the contract by both parties have been fulfilled, both parties have fully performed as promised, the sales contract is no more. It would be discharged. In our sales contract, closing is full performance. When the buyer buys and the seller sells, both parties has performed as promised, and that contract will be discharged at closing. Impossibility to perform could end a contract. Let's say, for example, we're under contract and we find out your buyer is not going to get loan approval. Well, unless another lender can help us out or your buyer's got some cash laying around, it is impossible for them to perform as promised. That would discharge or terminate the contract. Flip that coin. If the seller, we go under contract and the seller loses the property to foreclosure, it's no longer theirs. The property has gone to the bank. It would be impossible for them to perform. Mutual agreement. I always remember, the parties agree to get into the contract and the parties can agree to get out. So they can both agree to part ways, mutually agree to discharge or terminate the contract. Operation of law could discharge the contract. We talked the other day about things that could make a contract voidable. Show me how many parties can make it voidable. Just one. So some examples we gave was the minor, the person that was intoxicated, the person that was under duress or under undue influence. If the court decides that they have the right to make the contract voidable, then operation of law would discharge the contract. Other examples of operation of law, we talked about fun things like eminent domain and adverse possession. If we're under contract and the seller loses the property for eminent domain, that's going to discharge our contract. The courts have taken the property and it's no longer theirs to sell. Material breach, just see breach of the contract. Again, our sales contract, or any contract for that matter, is very specific about what the parties' duties and obligations, responsibilities are. And if the parties don't do as promised, as spelled out in the contract, then they're in breach, and that could terminate or discharge our contract. Piggybacking just a little bit, let's go back to this idea of mutual agreement. Parties agree to get into the contract, they can agree to get out. Specifically with this mutual agreement, I don't want you to get so bogged down in these words, but just know that we have some options here. We could agree to release each other from the contract. I could release you from your duties and obligations, and vice versa. There's a novation again. We could agree to substitute a new contract, new terms, maybe even a new party. Agreement of the parties. Modifying our agreement. We could agree to something different than what we originally agreed to. We called it round 2 of negotiations a few minutes ago. We're getting more and more into the parties' responsibilities and what their options are. Accord and satisfaction is like partial agreement. Somebody is agreeing to accept something less than what we originally agreed to. It's not what we originally agreed to, but the party accord and satisfaction says, all right, I'll take it in order to complete this performance. Maybe in the contract, for example, maybe a builder of a new construction property promises a specific brand of appliance. And when the builder goes to order that specific brand of appliance, it's not available. So the parties may agree to do accord and satisfaction. The buyer may agree to another brand. Be very, very careful about specifics like that. Because if you put Whirlpool dishwasher in the contract, you are expected to deliver a Whirlpool dishwasher. Does that make sense? And if Whirlpool is not available or they're sold out of dishwashers, then we would have to do an accord of satisfaction to re-agree to whatever dishwasher is available. Words matter. And then last here, this is cancellation. This is like the old school. Pre-internet days, when we actually had paper and we did everything on paper. If parties wanted to terminate, it wasn't uncommon for them to literally take their red pen and write the word cancel across the contract. I think that terminates it. It gets the point across pretty good. Again, the big picture of this screen, you guys, is to see that the parties can agree various reasons. The parties can agree to get out of the contract. They can agree to let each other go. Question comes in, does the realtor have to buy the fridge if they forgot to check to see if it was in this final sales contract? I'm not going to say you got to whip out your checkbook, but I'm going to say something's got to be resolved. So sometimes if it's my fault, I'm going to be more apt. If I forgot to put it in there, for example, that's my fault. That's not on my buyer or seller. It's my job to properly complete the contract. Some agents will say, no, I'm not whipping out a checkbook. I'm telling you right now what I say. I'd rather whip out my checkbook than face disciplinary action or go to court over a refrigerator. Choice up to you. So do I have to? No, but I may face legal or disciplinary actions. What we need to understand is we need to know that we're getting all the terms in the contract we want to try to avoid y'all whipping out your checkbooks. Does it happen? Yes. But remember, you guys, the real estate commission can't find me. They can't make me whip out my checkbook. However, they can discipline my license. If they take me to court, the judge could make me pay for the new fridge. Does that make sense? So it just depends on what avenue they go. Again, this agent, if I mess up, let me just write you a check so we can all move on. That's my personal opinion, and we all know what we say about that. Somebody said you could get you a new beer fridge. Yes, you could get a nice fridge if this was your agent. Yes. And a beer fridge and a dorm fridge for the backyard. I mean, if you're gonna do it, go big or go home, right? Some general rules for interpreting contracts. When we talk about interpretation of contracts, we're talking about the courts. We're talking about the judge. So if we hand the judge a sales contract and say, interpret this for us, there's certain things that the judge is looking for. Remember the parole evidence rule. They're making sure that all those points of negotiations are in the contract. A couple other things to know. The courts are going to interpret the contract as a whole. They're not going to piecemeal it. They're not going to break it up and say, well, this page 1 and 2 are valid, but 3 and 4 are not. It's either all valid or it's not. Same thing with any addenda that have to be added to it. Words are going to be interpreted per their ordinary meaning. Brokers, guys, we have our own language. And frankly, right now, I'm teaching you how to speak broker. Our jargon, our lingo, all of our abbreviations and acronyms do not belong in the sales contract. We need to be completing the terms of the sales contract so a buyer and seller can pick it up and understand what we're saying. So keep our jargon out of it, keep our broker speak out of it, and make sure the words you put in there can be interpreted by those that don't speak broker. And then ambiguous terms, this is just any unclear or uncertain language. So if you're putting verbiage in on behalf of your buyer or seller, make sure that everybody can understand what that means. Otherwise, the court's going to be in favor of the party that didn't put that verbiage in. So when in doubt, run it by your broker in charge, run it by a peer to see, sometimes having another set of eyes on it, sometimes removing yourself from the situation helps us see it a little bit clearly. So when in doubt, find out. It's another one of my super simple philosophies, by the way. When in doubt, find out. The resources are out there to make sure that we are properly completing these offer to purchase and contracts, any sales contract. Contract remedies. What happens if we don't make it to fulfillment? What happens in our sales contract if we don't close? Remedies must be spelled out in contract. So again, any good legally binding contract is going to spell out what happens if either party doesn't fulfill their promises. And we have several different contract remedies in basic contract law. These that we're looking at right here are your money remedies. Compensatory damages. If somebody is going after another party for compensatory damages, the non-breaching party, the party not at fault, is going after the party at fault to be reimbursed for the money that they have spent because of this contract. Compensatory damages are trying to make the non-breaching party whole again. I'm not going after you for pain and suffering. I'm going after you to make you whole. I, as a buyer, spent money on a home inspection. I paid for an appraiser. I put down deposits and fees. I put money into this. If the seller terminates, I just want my money back. I want to be made whole again. And compensatory damages would do that. One thing I like to remember with compensatory damages that you may want to write down, compensatory damages can be proven with receipts and invoices. I can show you that I spent this money. I can show you that I paid for the home inspection. I can show you that I put this deposit down. I can prove to you with receipts and invoices. And had you not have contracted with me, I'd have never spent this money. So now that you want out of the contract, I want my money back. If in that example, the seller is not willing to sit down and write out a check on their own, the buyer can take them to court. The buyer can sue, take those receipts and invoices to the judge. I'll come back to liquidated damages in just a second. Consequential damages, these are special damages. This usually occurred because somebody didn't meet their contractual obligation. They go like beyond the contract themselves. This is kind of your pain and suffering. So let's say, for example, consequential damages, the buyer's home inspector damages the property. We couldn't predict that. I mean, accidents happen. We could predict that, but we don't know specific. In that case, if the buyer doesn't buy, the seller may be able to go after the buyer for those special damages. Your home inspector, maybe they put the ladder up on the side of the house and they knocked off one, or they scratched the siding, or they knocked off a piece of the, the stone exterior or whatever. The seller, in that case, if the buyer doesn't buy, the seller could go after for consequential damages. Again, if the buyer's not willing to sit down and write out a check on their own, the seller can take them to court. The other money damage we have then are liquidated damages. We see these spelled out in our sales contract. With liquidated damages, we agree going into it. If you breach, this is how much I'm going to get. It's already been decided. It's part of our negotiations. It's part of our contract terms. In our sales contract, we're going to learn that the seller's remedy for the buyer's breach is liquidated damages. We agree going into it. If the buyer breaches, this is how much the seller's going to get. We could agree to $1. We could agree to $100,000. It's all negotiable. So these are our money remedies in the event the parties don't perform, in the event the parties don't agree. We have some other remedies too, though, that aren't about money. Another contract remedy not about money is called specific performance. And with specific performance, one party has breached, and now the injured party is going to the court, taking them to court, and asking the judge to make that party perform as promised. You gave me your promise in the sales contract, and now you're breaching. I'm going to take you to court. And if the judge rules in favor, they could make the party perform. In real estate, where we see this, or where we might see this, is with seller breach. If the seller terminates their contract, the buyer has the option to take them to court for specific performance. And if the buyer wins, the judge could make the seller sell. That is their obligation. That is their performance in the contract. The judge could make the seller sell. Now, I hesitate from words like always or never. Those are big words. Remember, absolute words. I'm not going to say you're never going to see the seller go after the buyer for specific performance. But what I am going to say, it's incredibly rare in North Carolina, and it's going to be awfully hard to win. For more information on that, you need to talk to your attorney. For our purposes, where we see this, what we need to know, the buyer going after the seller, if the seller breaches, the buyer can make them sell. They can make them perform as promised. Another remedy then, non-money, is a rescission. If you rescind your contract, you take it back. Both parties are put in the original position they were in before we went under contract. So if the buyer put down any deposits, they'll get their money back. Both parties go about their lives as if this contract never happened. You rescind your contract, you take it back. Anybody that put down deposits get their money back. Everybody goes about their lives as if it never happened. You guys got those chats still set to private? Remind me in a private chat, how many days does a buyer have to rescind their contract in a timeshare? How many days does the buyer have to rescind their contract with a timeshare? They can take it back. If they put down any deposits, they'll get their money back. Remember what we remember about timeshares. What do we remember about timeshares? Something about 5, 5, 5, 10. What we tend to remember is jazz hands, but the stuff up to that, 5, 5, 5, 10. So in a timeshare, that's right, in a timeshare, the buyer has 5 days to rescind their contract in a timeshare. Again, they take the contract back. The timeshare developer gives them their money back, and it never happened. All right, one more. How many days does the buyer have to rescind their contract in a new construction condominium? How many days do they have to rescind their contract in private chat in a new construction condominium? How many days does the buyer have to rescind a new construction condominium? 7. We'll do that. 7. 5 days timeshare, 7 days new construction. Those are our examples of rescissions in real estate in our purposes. Questions on that? Specific performance or rescission? Not a contract remedy, but terminology to understand when dealing with contract remedies. There's something out there called statute of limitations. Statute of limitations isn't specific to real estate. It's very, very specific to contracts or suing everybody. What specific or statute of limitations says is that if you want to take somebody to court, you have a certain amount of time to do it. And once that statute of limitations is run out, you've lost your right to sue. Now, how long do you have? The answer to that is it depends, and you need to talk to an attorney. What we need to know is when the statute of limitations has run out, the party has lost their right to sue. So my suggestion, when my buyer or seller call me and say, I'm going to sue the other party, my suggestion is do it sooner rather than later. Get with an attorney. Because once the judge has decided that it's been too long, you're done. So just do it sooner rather than later. Statute of limitations. All right, contract verbiage. Let's bring this all home for us. I'm not an attorney. I can't practice law. Part of the practice of law is drafting legally binding documents. I cannot draft. Please write that down. Agents get themselves in trouble for drafting verbiage in a sales contract. Guys, we are provided with a pre-printed form, and our job is to fill in the blanks. And those blanks that we're filling in are asking, it's very specific. You can't just put any old thing in a blank because you see a blank. What we're filling in the blanks are very specific. We are not drafting legally binding documents. I cannot draft amendments. I cannot draft addendas. I cannot draft, period. This is one of these things. Remember when we were talking about OLCAR? We said we follow our clients' lawful instructions. This is one of these things. This is going to come up. And we're going to have to say, legally, I can't do that. Buyers and sellers will ask you all the time, can't you just add this? Can't you just put this in? No, I can't. And they're going to ask because, I mean, one, you're their one they communicate with, but two, we're a lot cheaper than an attorney. So they're going to ask. Remember, it's not their job to know my job. It's my job to know my job. And no, I just can't add. I just can't draft. Now, interestingly enough, the parties to the contract can add, draft, delete. They could mark that contract all up because they're the parties. When we're talking about the sales contract, I'm talking about the buyer and the seller. So they could take their red pen to our pre-printed form and hack it all up. Just because they can doesn't mean that they should. If your parties pick up their pen and say, well, I'm going to fix this, we need to highly recommend that they talk to their attorney, because I can't even tell them, because I'm not an attorney. If you make this change, if you add this or delete this, how's it going to affect the rest of the terms of the contract? It's all connected. It's all related. Remember, it's all one document. So the parties to the contract can, but that does not mean that they should. Questions or comments on that? The last little piece of Unit 9 talks to us, well, no, not necessarily, but about auction sales. We talked about auctions very briefly when we were talking about working with real estate agent disclosure. The auctioneer doesn't have to do the disclosure with the buyer of an auction sale. It's presumed that that buyer knows that the auctioneer represents the seller. Remember, we're not even going to think about an auction unless the test question specifically asks you or says something about an auction. Thumbs up, we just heard me. They don't even exist unless your test question says something about an auction. With an auction sale, there are two types of auctions, one with reserve and one without. An auction with reserve gives the seller the right to stop the bidding at any time if they're not happy with the progress. Maybe the opening bid isn't enough for them. Maybe the high bid isn't enough. With reserve says the seller has the right to stop the bidding at any time. Without reserve then says they get what they get. Another thing to understand about the auctioneer is duly licensed. So they have a real estate license, but they also have the auctioneer's license. It's the auctioneer's license that gives the auctioneer the right to bind the seller. What do I mean by that? I mean, when that gavel comes down and the auctioneer says sold, congratulations, folks, we're under contract. The auctioneer has bind, they have committed the seller. Obviously, the next step is going to be to put that thing in writing. But that gavel's come down. The auctioneer said sold. We are under contract. Remember, as a real estate agent working with buyers and sellers, we're a special agent and we can't bind. But that auctioneer license gives them that extra ability, that extra authority. The last thing in Unit 9, I got to go off book for a second. And this is actually covered in Unit 10, but I always forget about it. So I just kind of throw it at the end of Unit 9 when we are talking about verbiage and terminology to understand basic contract law. So in Unit 10, you see I got the reference here. But the word to understand is to introduce us to is something called a contingency. And a contingency says it's dependent on something else. So I'm not expected to legally perform if this first doesn't happen. Me completing my contractual obligations is dependent on something else happening. And in real estate, where we sometimes see contingencies, we could create a contingency that says, I'm not legally obligated to buy your house if I don't get loan approval. So, in other words, if my loan gets denied, I'm off the hook because it's dependent, me buying your home is dependent on me getting loan approval. Another contingency that we see in real estate sometimes, I cannot buy your house if I don't first sell or lease mine. So if the parties agree to this contingency and my house doesn't close or rent, then I'm not legally obligated to buy yours. I'm not on the hook to buy yours until mine sells. So contingency says, in order for me to perform, legally perform, something else has to happen. And if that something else doesn't happen, I'm off the hook. This is what you and I need to know about contingencies. The sales contract that we use the most often, the one that we are going to talk about in Unit 10, has no built-in contingencies. With that being said, the parties can agree to add a contingency. We can agree to add, I'll buy your house if I first sell mine. I'll buy your house if I first get loan approval. It's a negotiation point. The other thing for us to know about contingency, this is, we almost say we have a form for everything. We have a form for most things, for the majority of things. Contingency is one thing we don't have a pre-printed form for. So if the parties do want to create or draft a contingency, now we're getting attorneys involved. We do not have pre-printed forms. We do not have verbiage in our contracts for contingencies. But the parties can agree to add one. And if the parties agree to add a contingency, now we are legally, contractually obligated. Again, if my house doesn't sell, I don't have to buy yours. Questions on that contingency?
Miss Julie, so if we did a contingency and we added on, would we be doing the other A word? What did we say? Not novation. It would be okay.
No, it would be a contingent. So it does add to, but a contingency is kind of something different than the addenda. It does add to, but it's not an addenda. It's a contingency. It's another agreement. We were seeing in the crazy sellers market, for example, crazy sellers market. We were seeing things like, I'm not buying your house if it doesn't appraise. We had an appraisal contingency that we were seeing quite a bit. The parties can agree, and that's what we need to understand. They're not built in, but that doesn't mean the parties can't agree to do it. Question came in the chat about specific performance. Let me go back just 1 second so we can see it. With a specific performance, the word to see is perform. So some party, the non-breaching party, has to take the breaching party to court. And they say, this person promised they were going to do this. They promised they were going to sell their house. And then they backed out. They changed their mind. I'm taking that party to court to make them perform. And what's their obligation? To sell. If the judge awards, they can make the seller sell. They can make the seller perform as promised. Seller breach, correct. So the buyer can take the seller to court to make the seller sell. I'm not going to say you're never going to see this happening for buyer breach because I don't like that word never, but I'm going to say it's incredibly rare. Because if we think about it, let's say the buyer has to terminate because they don't get loan approval. And they've talked to a couple different lenders and no lender will give them money and they don't have cash stuffed in a mattress. I mean, you can't, the judge can't make the buyer buy in that case. So usually what I want you guys to know where we see specific performance is seller breach. In my career, how many times have I seen people go to court that I know of? Zero. That doesn't mean it doesn't happen. I do know of cases, but none of mine, none of mine transactions. My firm, we went to mediation last year. Buyer moved in and found problems. The seller said no on the RPODs. The buyer moved in and said, this is broke. You lied. And they went to court and they ended up hashing it out over mediation. I don't know the result. So my experience, none. Personal experience, none. Does it happen? Yes. That gets us through Unit 9. Again, you guys, please hear me. The trick to Unit 9 are those key terms on page 255. Knowing what the words mean. What we're doing is we're introducing you to the vocabulary to build us up to our sales contract in Unit 10. So knowing those words, those key terms. The key point review is your very nice summary of the unit. And then you got that student quiz on page 268. Again, Unit 9 does not give us the authority to practice law. Sometimes we think we know it all. Even if you know, I can't say. You need to know, remember, staying in your lane. And when it comes to acting like an attorney, I can't do that. Questions on Unit 9? Other questions on Unit 9? Good questions. All right. Let's take 10. When we come back, we're getting into 10, which is our standard sales contract. That's right, Jen. You come in with an advantage here, don't you? Nice. All right, we're back. So I'm going to take attendance. The camera's popping back on. All right, so I'm gonna take attendance. Oh, you guys are in. Lynn, Ashley, I got you. And we're ready to jump into Unit 10. Unit 10, now we're getting into the real estate piece of sales contracts. So we're going to take what we just learned from that basic contract law, and we're going to talk about how we use it in real estate specific with our offer to purchase and contract and some various practices. Our guide, a roadmap to this unit, we're not going to look at any sales contract. We're going to look at a specific sales contract. And specifically, the sales contract we're going to look at is our offer to purchase and contract standard form 2T. Don't need to know the number. But this is probably the most commonly used pre-printed contract that we have. So we're going to spend some time looking at the verbiage on this one. We're going to talk about some sales contract procedures. So we're going to talk more about, we're going to explain contract formation. We're going to talk about that. There's this magic moment in time when it goes from being an offer to a contract. How do you know when you are under contract? And we're going to look at that. We're also going to talk about multiple offers. And then the last thing in Unit 10, some alternative land conveyance methods. There's some other options to convey property, some alternative methods. So we will look at those as well. So let's talk about not just any sales contract, but specific, our offer to purchase and contract standard form 2T. That comes from the North Carolina Association of Realtors. That's NCAR. All or most, I should say, most of our pre-printed forms that we use are NCAR forms. Most of the pre-printed forms we use do not come from the Real Estate Commission. Remember, the Real Estate Commission is a licensing body. They govern our license with the best interest to protect the public. A benefit of joining the National Association of Realtors. Once you get in the national, then you get access into the state level. And with the state level, they provide you with pre-printed forms to use. Many of your firms or your future firms are probably members of NAR, thus NCAR, because a huge advantage is that they offer us those forms. Understand that standard form 2T is not the only sales contract that we're allowed to use. And I think this is a problem topic. I think we think 2T is it because I put some fear into you about not drafting. But understand, we're allowed to use any sales contract as long as it was drafted by an attorney. Some firms have their own contracts, and that's fine. They can use those, but they're drafted by an attorney and they meet certain commission rules. A lot of builders, for example, don't use NCAR standard forms. If you've ever bought new construction, you're probably using a builder sale contract. So make sure we know that any sales contract is okay as long as it was drafted by an attorney and all we're doing is filling in the blanks. We're just going to focus specifically on 2T because that's the one that we use the most often. I mentioned commission rules. Again, you don't need to know the numbers. I just have them here for reference. Commission Rule 58A.0111 is the rule that addresses brokers are prohibited from drafting. So it's not just an advice. Commission rule says we cannot draft. If it's discovered, if it's learned that we're drafting, then we very well likely will face disciplinary action. There's also Commission Rule 58A.0112 that spells out the requirements of any sales contract, pre-printed contract that we use. So again, we just can't use any sales contract. It's got to be drafted by an attorney and it has to meet the requirements of Commission Rule 58A.0112. So just to be aware, don't need to know the number, but just be aware there's rules out there addressing this stuff. If I go off book for just a second, North Carolina uses sales contracts. Specifically, our offer to purchase and contract is twofold. It's used as an offer, and upon acceptance becomes a legally binding contract. So North Carolina is a sales contract state. Compare that to the letter of intent next. An offer is a document we can use for two purposes. We can use it to make an offer, negotiate an offer, and upon acceptance, it becomes the legally binding contract. If we compare a sales contract to what other states may use, something called a letter of intent. With a letter of intent, it's just a statement. It might even be on a napkin or a piece of paper, an email. It's just a statement of the terms. Like, if I offered you these terms, would you find that acceptable? A letter of intent. In North Carolina, a lot of times commercial agents use a letter of intent. And if we agree to the terms of the letter of intent, then a sales contract will be drafted up with those terms. So again, North Carolina, we use a sales contract mostly for residential. We can offer, negotiate, and agree all on the same document. It's pretty handy. Back to our book. You can see I'm skipping ahead. We're passing back to 289. We're passing that whole contract in your book. What is that? 273 to 288. That is an old contract. So remember, never look at a form in your book. Always go to the online learning system. So we'll go out there in just a bit and look at 2T, the current one. Skipping ahead though for the moment. Big rule of thumb, big picture. In our sales contracts, agents don't belong. The sales contract is an agreement between the buyer and the seller. What's that have to do with me? Absolutely nothing. I'm just facilitating, I'm helping. The big picture is brokers don't belong in the contract. Specifically, the commission says we cannot have any mention of our compensation. Where do we agree to our compensation? Where do we decide, determine how I'm paid, how much, when, all that? I'm seeing mouths move. That's all in our agency agreements, you guys. Commission is in the agency agreements, never in the sales contract. Everybody with me? And we got to have those agency agreements all agreed and in writing before I can present or receive an offer on behalf of my client. So we have commission hashed out before we present this offer, before we go to the next phase of the contract of the offer and acceptance. The other thing specifically that they mention is we can't have any liability disclaimer. You can't slip a provision in there to protect yourself. So maybe, for example, the buyer says, no, I don't need a home inspection. Okay, that's fine. That's on them. I can't make anybody do anything. That doesn't belong in the contract. It's not that it's not an agreement between the buyer and the seller. That's all that belongs in the contract. So again, the big picture, I can't put anything in there about me. I don't belong. I'm not a party to the contract, to the sales contract. Contracts took on a new life not too terribly long ago, and we moved from paper to e-documents, e-signatures, e-initials. There's an old saying, technology moves faster than the law. So I'll be honest, it took real estate longer than other industries to adapt e-signatures, e-documents. It didn't just happen overnight. It had to pass the courts, pass the laws. I'm actually old enough, I've been in real estate long enough to remember when we got e-signatures, when we got e-documents. So it's not that terribly old. Specifically, the rules, the acts, one of the acts that we have that addresses our e-commerce is called the Uniform Electronic Transactions Act, or the UETA. We also have a state level called the North Carolina Uniform Electronic Transactions Act. They both say pretty much the same thing. But this is the act that addresses that e-commerce, that e-trade, and it allows the parties to use an e-signature to count as their binding signature. When the parties get a request to sign a document, to e-sign a document, part of the terms and conditions or terms and agreements, how often do we read those things? But part of those terms and conditions, you're agreeing that your e-signature counts as your legally binding signature. Anybody ever signed anything electronically? Well, I think you guys had to do for Lane, right? You had to do your agreement, your contract for Lane electronically. How often does your e-signature look like your hand signature? Not often. But by agreeing to those terms and conditions, you can't stand in front of a judge and say, this isn't my signature. You're agreeing that your e-signature counts. So let's go back just a little bit. In Unit 9, we introduced you to the idea of this contract formation. It's got to start with an offer. The offer is considered, maybe it's negotiated, maybe we have a counter offer or two, but it's eventually got to be accepted or rejected. So let's go back and revisit that. And we're actually going to build on it a little bit more. And we're building to that moment in time that it goes from being an offer to a legally binding contract. So talking about our offer and acceptance, the offeror makes the offer to the offeree. Remember, we're not getting bogged down in buyer and seller. The offeror is the giver or the creator of the offer, however you want to see that. The offeree then is the one that's receiving the offer. Most of the time, the buyer makes the offer to the seller. But there have been cases I've had experience where the seller makes an offer to sell to a buyer. So again, we're not getting bogged down in buyer and seller. It's about the giver of the offer and the receivee of the offer. Every time, anytime an offeree receives an offer, you always have three choices. The offeree can accept the offer. If they accept the offer, they are agreeing to, here's our absolute word, all of the terms exactly how they are. Any change is not acceptance. The offeree also has the right to reject the offer. If they reject it, it's dead on the table. Here's an offer, I reject it, we're done. Parties go about their lives, everybody moves on. You cannot revive a rejected offer. It's dead, you guys. There is no reviving it. It is dead on the table. You could go back and make a brand new offer with those exact same terms, but you can't go back to the rejected offer. There is no going back once an offer has been rejected. And then the third option, the third choice that the offeree has is to counter. A counter offer is a rejection. A counter offer is a rejection. It's a rejection with a but or a however. Counter offers often sound something along the lines of, I'm good with all the terms, but the purchase price. I'm good with all these terms except for this, this, and this. It's the jumping point of negotiation. And understanding a counteroffer is a rejection. I've rejected your offer, and now I am making a brand new offer to you with some of these terms, but my new terms, those buts. With a counteroffer, so let's set ourselves up here, a contract formation law. You have the buyer, and in our example, we're going to have them start as the offeror that makes the offer to the seller, because this is what we see most often. Oops. And then on the other side of the contract formation law, we have the seller who's receiving the offer. So buyer makes an offer to a seller. The seller's three choices: they can accept it, agreeing to all the terms. They can reject it, making this offer dead on the table, or they can counter it. In a counter offer, the seller has rejected the buyer's offer as it is. And with a counter offer, those roles are going to reverse. The seller is now making a brand new offer to the buyer. Once the seller counters, the roles reverse. Now the buyer is the offeree. What are the buyer's three choices? They can accept it, reject it, or counter it. Let's rattle that off together. Make sure we're all good. What are the offeree's three choices? They always have the options to accept, reject, or counter. Everybody with me? Every single time you get an offer, no matter how many times we counter, every time we counter, those roles reverse. The offeree always has three choices. There's no magic number on how many counters we can have. We could go the rest of our lives countering. The only thing that would end a counter would be acceptance or rejection. It keeps going until somebody accepts or rejects. And ideally in a counter offer, we're getting the parties closer together. So let's say, for example, we are countering the purchase price. Typically, the seller starts up here and the buyer starts down here. And each counter hopefully brings us a little closer and a little closer together. We're trying to find what that happy medium is, what that point of the negotiations is, where both parties are satisfied, where both parties have acceptance. There is a very definitive moment in time when this offer, if it's going to go under contract, there is this very definitive moment in time when the offer becomes a legally binding contract. So the offer has been made, it's been considered. Step number one, I need the offeree to accept. And remember, if they're accepting, they're agreeing to all of the terms exactly how they are. For your exams, when you see the word accept, know that it has been signed. In the real world, you need to verify it. But for your exams in pre-licensing world, please write that down. When you see on your test questions that the offeree accepts, you know that it has been signed. In the real world, if you have verbal acceptance, you have nothing. Statute of fraud says it has to be in writing. So for our purposes, for your exams, you don't have to question it. When you see that the last offeree accepts, you know that that means that it's been signed. That's step one. We are still not under contract yet. The second step, the second thing that must happen is that the fact that it has been signed has to be communicated to the person making the offer. So step one, last offeree accepts. Step two, communication of acceptance has to cross our contract communication line The person that makes the offer has got to know that their offer's been accepted. How we communicate acceptance can happen in any different method that the parties agree to. I could call you and say, my guys have accepted. I could text you. I could send you the signed contract. We are not delivering the instrument. We are communicating the fact that it has been signed. And that communication has to cross the line from the last offeree to the last offeror. So let's take what we just learned, what we have. This is a huge slide, you guys, not just for your test, but for the real world. Yeah, what do y'all think? Real world, future broker hats on. Do you think it's important that you know when you can call your buyers and sellers and say, congratulations, you're under contract? And before you make that phone call, you need to know that you are under contract. So how do you know that? You have acceptance and you have communication of acceptance. So let's be a buyer's agent. You're a selling agent working with the buyer, and you're out looking at property, and you show them one this afternoon and they say, ooh, this is nice. I like that. Let's write it up. So you fill in the blanks of the sales contract on their behalf. This is all a conversation we're having with the terms that they are willing to offer. You draft up the sales contract, the pre-printed form on their behalf. Then the buyer's agent communicates with the seller, the buyer and the seller. I shouldn't have said agent. I'm going to bring agents into the mix in just a second. The buying side presents the offer to the selling side. Again, I'll bring agents into the mix in just a second. The seller has received an offer, and as the offeree, they have three choices. They can accept it, reject it, or counter it. If they counter it, we know that those roles reverse. The selling side, listing side goes to the selling side and says, we have countered your offer. The seller is good with all the terms, but this, and this. The buying side now becomes the offeree. The buying side now has three choices. They can accept it, reject it, or counter it. Are we hearing that over and over and over again? Accept, reject, or counter. The buying side says, yep, I'm good with all of the terms of the seller's counter. I accept it. For your exams, you know that means that they have signed. Acceptance means they sign. We have step one. We have acceptance or signature of the last offeree. The other thing that we need to have happen, must happen. The fact that the buying side has signed it, that communication of acceptance, must cross the line. The person that made the offer has to know that their offer has been signed, that their offer has been accepted. We're going to run through some more scenarios. Again, I'm going to throw the agents in the mix in just a second. I'm going to always encourage you guys for your exams, for your practice tests as you're building up for your exams. When it comes to this test question or these test questions on your test, y'all, that question is like this long. It's the longest one you got. It looks like a paragraph because you're going to go through some counter offers. You're going to have terms of an offer. You're going to have some counter offers. It's going to be back and forth. It's a very real world question. I highly recommend on your scratch paper that you draw out the contract formation wall because you need to see who the last offeree is that accepts it and who the last offeror is that needs that communication of acceptance. We must have those two things. Offeree signs, and then the fact that it has been signed has got to cross the line and go back to the party that made the offer. What's that mean if agents are involved? When it comes to contract formation, sales contract formation. We stand on the same side as our client. So communicating to me is exactly the same as communicating to my client. In sales contracts, what you tell me is exactly the same as telling my buyer or seller. So again, same scenario we were just in. You're out, you're the agent with the buyer out looking at property. They find the one, they say, I want to write it up. You help them fill in the blanks, the terms of their offer. Now that agents are involved, the buyer's agent is going to have the buyer sign their offer, showing the seller that they're serious. It's a legit offer. The buyer's agent is going to communicate with the seller's agent, say, we have an offer. Seller's agent is going to call their seller and say, we have an offer. This is what we have. And here are your three choices. You can accept it, reject it, or counter it. The listing agent can walk the seller through. I can offer advice. I can offer my opinion. Bottom line, it's ultimately the seller's decision, but we can guide and advise through this negotiation process. The seller decides that they want to counter. So the listing agent goes back to the selling agent and says, we're good with all the terms, but this, and this. Buyer's agent goes back to their buyer and says, hey, we have a counter. You have three choices. You can accept the seller's counter offer, you can reject the seller's counter offer, or you can counter the seller's counter offer. In this case, the buyer says, I accept. The buyer tells their agent that they are good, they have signed. When the buyer tells their agent that they have accepted, did that contract communication cross the line? No, we're still over here on this same side of the line. Buyers talk to their agent. We are all over here on the same side together. Buyer agent calls listing agent and says, my guys have accepted. Did that communication cross the line? Did it go over the contract formation? It did. Congratulations, folks. We are under contract. Communicating to me is just as good as communicating to my party. Communication has crossed the line. Maybe I called you and said my guys have accepted. Maybe I sent you the signed contract. Again, we're not talking about delivery of the contract. We're talking about communicating the fact that it has been signed, communicating the fact that it's been accepted. As the listing agent, in this case, what's the very next thing you need to do? Yep, I'm seeing mouths move. Listing agents, you need to call your seller and tell them the good news. And this phone call isn't, are you sure you still want it? This phone call is, congratulations, you are under contract. Because communicating acceptance, to me, is just as good as communicating to my party. Negotiating, terminating an offer or contract, all communication with sales contracts, once you tell me, is just as good as telling my buyer or seller directly. So I need you guys, because again, that test question that's this long, I'm serious, it's this long. And it's gonna, where it throws you off is it says the buyer's agent, for example, the buyer's agent or the buyer calls their agent, says I've signed. But what we need to see is that communication is still on this side of the line. And I want you guys to draw this thing out on your scratch paper, because I need you to see that communication actually crossing the line. Fair enough? Draw it out, practice it. We'll see some more examples, of course. Contract formation. There's a very definitive moment in time when it goes from being an offer to a contract. And we must have acceptance of the last offeree. And that acceptance has to go back to the person making the offer, or it's got to cross the line. When we talk about different methods of communicating acceptance, again, please see that verbiage. We're talking about communicating the fact that it has been signed. And quite frankly, you guys, any method of communication of acceptance is allowed as long as the parties agree. So we could do traditional methods. I could pick up the phone and call you and say, my guys have signed. You could fax over that signed contract, that confirmation. You could snail mail it, FedEx it. You could email it, text it, e-signatures, as carrier pigeon, doesn't matter. As long as the parties agree. And we have a page in our sales contract that spells out how the parties want to be notified of acceptance. What is an acceptable form of communication? A lot of us don't have a fax machine anymore. Well, if I don't have a fax machine, then a fax machine is not an acceptable method of communicating. There are people out there that don't have an email address yet. If they don't have an email address, then that may not be an acceptable method of communication. And that's why we have the page in our contract that spells out what acceptable methods of communication are. When it comes to the methods of communication, you only need that communication of acceptance to cross the line one time. Everything after that is a follow-up. So for example, back to your practice questions, back to your exam. It may tell you that I called you and told you my guys to sign, and then I followed it up with a text telling you that I left you a voice message. Which method of communication put us under contract? You can show me one or two. Which one put us under contract? When I called you, the first time that communication crossed the line. The fact that I texted that to you is just a follow-up. You may have a very real world scenario. I'm out and about this afternoon. I'm out showing property and doing my thing and da-da-da-da-da. You call me and say, my guys have signed. And I say, great, awesome, thank you. Guess what? We're under contract. Even though I'm out and about and you're out and about and you hadn't sent me the contract yet, I know you'll send it. You'll get it to me as soon as you get back to your laptop. But the fact that you called me and said, my guys have signed, we're under contract. The next step is going to be to make sure everybody has the signed contract. What questions on this do I have? There's a couple special rules with some of the methods of communicating acceptance. There's something called the mailbox rule. If we're going to communicate acceptance snail mail, communication of acceptance snail mail, the mailbox rule says that communication of acceptance has crossed the line when the properly addressed envelope has hit the mailbox. So if you're going to mail, mailbox rule, it's like the oldest rule we have. This goes back to like the days of the Pony Express. And the fact is, we're not doing snail mail much anymore, but don't we still have mailboxes? Don't we still have a post office? So the mailbox rule is still out there, although we're not using it as much. It's still out there, so we need to know, using snail mail, When is communication of acceptance happen? And communication of acceptance per the mailbox rule happens when that properly addressed envelope is placed in the mailbox. The fact that the other party won't receive it for a couple days is irrelevant. If you're communicating acceptance via email or text, communication of acceptance happens when it hits the recipient's inbox. Not when I send it, not when you open it, but when you receive it. Communication of acceptance is happening. See an example here about the parties agreeing to the different methods of communicating acceptance. So an owner offers to sell to a prospective buyer. The offer states that the acceptance must be made by email message only. There's only one acceptable form of communication in this transaction that these parties agree to. Instead, the prospective buyer leaves a phone message informing the seller that he's accepted. Guess what? We don't have a legally accepted offer because phone message was not a method that we agreed to. So understanding the parties have to agree how we communicate, and they do so through our sales contract. They help us out. And we'll see that page in just a bit when we look at our sales contract. What questions do I have on contract formation, acceptance, communication of acceptance?
Miss Julie, what if you could have just say we have two potential buyers, and has it ever happened that one they both signed, and is it who gets to the phone first to call? Okay.
You got it. You got it. Because I have to have both pieces. So if the seller just starts signing all offers that come in, sign, somebody's communication of acceptance crosses the line first. That's very poor management of the broker if and when that happens, right? But could it? Sure. Which one's going to win? The one that's communication of acceptance crossed the line first. I mean, think about, I told you guys the last class, this crazy seller's market we were just recently in. Y'all, I'm not kidding. One of my teammates had a listing and they ended up getting 45 offers on that listing. That means 44 of them got rejected, right? There was only one that could be accepted. There was only that one. And that's a lot to go through. We're going to talk a little bit about that multiple offer. But yeah, we just need to be very careful, especially the communication piece. And I think it's important as brokers that we understand, again, if you have verbal acceptance, you have nothing. So we know acceptance means that it's been signed, but when you get in the real world, I need you to verify it. So let's say you and I are the agents in this transaction and we're negotiating for our buyers and sellers. In the real world, you call me and say, my guys have accepted. And my knee-jerk reaction is going to be to say, but have they signed? You say, well, they're at work and they go to lunch at noon, so I'll go ahead and have them sign at noon. What do we have at that point? Nothing. Nothing. And that's where brokers need to make sure, guys, again, words matter. Don't tell your buyers that the sellers have signed if they haven't. There have been cases. I ran into this myself. I was doing an open house many years ago. And a couple came into my open house and they walked through the home and they got done. And I said, did you guys have any questions? And they were like, we're just kind of out looking. They said, we're not gonna lie, we're a little discouraged. We were under contract, but the seller backed out. And I said, oh man, I'm sorry to hear that. But it wasn't your house, da 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 da. And they said, well, they verbally accepted our offer, but before they could sign, a better offer came in. The seller's always going to go for the one that's best for them, right? So there's a lot that can happen from yes, I accept to actually having that acceptance. So and that's where in the real world we need to verify. And when you guys come see me in post licensing, I'm going to tell you when that other agent calls you, you need to, without even thinking, say, that's nice, but have they signed? Again, for pre-licensing world, keep this simple. When you see accept, you know that it has been signed. And then the second thing we're looking for is that communication of acceptance to cross the line. And then those people said, we just don't play that game. And I thought, well, it's not really a game, it's contract formation, but I'll let your agent deal with that, that's what they're doing. Buyers and sellers don't necessarily understand the negotiation process. So it's really important that when we're telling our clients that we're under contract, that we are in fact under contract. And we're not saying that until we have acceptance and communication of acceptance. What other questions do I have on that? Termination of an offer. Note that that word says offer. We already talked about terminating a contract, our contract remedies, money damages, specific performance. Now the question is, what terminates an offer? Well, we've already said rejection and counteroffer terminate an offer. The offeree, the receivee of the offer would terminate if they fail to respond with any stipulated time frame in the offer. The offeror or the one making the offer has the right to put an expiration date on their offer. They can say this offer is good until 5 p.m. on Friday, October 11th. And if we don't have acceptance by 5 p.m. tomorrow, that offer has been terminated. If we don't have a time frame on it, the offeror can terminate their offer within a reasonable amount of time. The offeror is free to terminate their offer at any time prior to acceptance, even if they put an expiration date on it. So I made you an offer today, and I said my offer is good until 5 p.m. tomorrow. If I find a property I like better this afternoon, I can take my offer back. So I'm going to say what I just said again, make sure we heard it. The offeror is free to take back their offer, terminate their offer at any time prior to acceptance. Offeror can terminate their offer at any time prior to acceptance. The other thing that'll terminate the offer of a sales contract, keep in mind we're talking about that sales contract between the buyer and the seller. If either party passes away during the negotiation process, the offer is terminated. So death of either party, buyer or seller, just talking about your sales contract. Fun fact, once you're under contract, death is not an out. Death is only an out when you're negotiating the offer. If buyer or seller pass away while we're under contract. Once we're under contract, their heirs are expected to carry through the terms of the contract. And if they can't or won't, they will suffer the consequences of breach. The thinking here is that the party's intention was very clear because we have a signed contract in our hand. So in sales contract, death is only an out when we're negotiating the offer. Questions? I know I'm a few minutes early, but I say let's go ahead and take a break. When we come back from break, we're going to get specific into our offer to purchase and contract standard form 2T. So not just any sales contract, but we're going to look specifically at talk about 2T, again, as that's the one that we use the most often. So let's take 10. All right. Welcome back. Cameras are coming back on, and please remember I need to see you. So I am going to take attendance. So some very basic sales contract things, no matter what document you're using, terminating an offer is terminating an offer. Any sales contract. So now what we're going to do, and I have taken attendance, so please make sure you tell me you're back. What we're going to do next is get more into specific conversation about our, thank you, offer to purchase and contract, specifically standard form 2T. Again, it's so important that you guys hear, this is not the only sales contract we're allowed to use. This is just the one that we use most often. This is the one you're going to see most often in the wild, which is why we're spending our time and our energy on this one. So before we get into it, most of our documents, not all of them, but most of our documents, the North Carolina Association of Realtors provides us with a supplemental document called Guidelines for Completing. So specifically for 2T, they give us these guidelines, help us how to know how to properly fill in the blanks. And a lot of our more commonly used forms come with these guidelines. You guys will have access to all that once you get licensed and you affiliate with your firm. Specifically looking at our 2T, the guidelines for completing, it gives us some specifics. It gives us some instructions to make sure that as we are completing these documents for our buyers and sellers, we're doing it properly. Never forget, these sales contracts are the legally binding documents between buyer and seller. It's my job to make sure these things get filled out properly. So when in doubt, find out. You guys have a ton of resources out there to make sure you're doing it right. One of them is just the guidelines. One thing that the guideline specifies is that when we're filling in the blanks, if at all possible, we need to type. If you find that you have to fill it out handwritten, please do so in ink. Don't use pencil or orange crayon to complete a legally binding document. So if all possible, type it out. Anytime you see a blank space, you need to fill in the blank unless the contract tells you otherwise. Sometimes it says only fill in this section if it's applicable. If otherwise, let me say that, otherwise, a good rule of thumb is that we're not going to leave a blank blank. If you have a blank, this situation doesn't apply, then we either need to use NA for not applicable. If it's a blank asking for a money, if we don't put a dollar amount in there, we need to be putting a 0 in there. Again, a very good rule of thumb. We're not going to leave blanks blank. And there's 2 reasons for that. If I leave a blank blank and I present an offer, it may make the other side wonder if I have presented a completed offer. Was it an oversight? Did I mean to go back later and put something in there? The other reasoning for not leaving a blank blank, I'm not giving the other side an opportunity to slip something in there. So by acknowledging that this blank is either not applicable, NA, or 0, lets all parties know we're on the same page. Be precise. We mentioned this, our jargon, my broker speak does not belong in the contract. You guys are figuring out in real estate, by golly, if we can make an acronym out of it, we're going to. That's broker speak, you guys. The general public doesn't know what RPOS means, for example. So we need to make sure we're spelling out those acronyms, spelling out that jargon, being precise with the verbiage. Everything needs to be acknowledged. They've changed, addition, or deletion needs to be acknowledged by initials, dates, or a new contract and novation by all parties. By the way, if you do a novation, you keep the old document, you keep the old contract. Because what do we document? Everything. So the new contract shows that we have replaced that, keep it all, document all those changes. And then we also have a duty, part of OLCAR says, is that we need to review the contract provisions with our party, may that be buyer or seller or both. I'm going to be very honest with you guys. Between me and you, many buyers and sellers do not read the sales contract that makes them legally bind, legally committed to each other. Why don't they read it? Because they trust us. They trust that we are familiar with the contract. We know the terms in the contract. We know what's in the contract that protects them. We've got to be familiar with the sales contract. Now, with that being said, even though they're not going to read it most of the time, I still have a duty. I always have a duty to make sure that they understand what's in it. Don't hand it to your clients and say, read this and let me know if you have any questions. We need to go through it and we need to make sure that they understand the bigger points, the bigger provisions as it relates to them. Every once in a while, you'll get a reader, but I'm telling you right now, it's not often. I have sent contracts out for e-signatures, and I always put verbiage in there like, let me know if you have any questions before you sign. And I don't know, 2 minutes later, the signed contract is back in my inbox. Do I think they read it in those 2 minutes? No, they just went through, sign, click, 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 and say, here you go. We don't have any questions. Whether they sign it or not, or excuse me, whether they read it or not, they're still legally obligated to the terms. So we need to make sure that we're going over those provisions that they're understanding. And it all starts with us having an understanding of what's in the contract. We're getting ready to go through the contract, not word for word, but we're going to go through the contract. We're going to have a discussion about the provisions. This will be your first introduction to specifically standard form 2T. When you guys come see me in post licensing, that's when we do the deep dive. That's when we go through 2T word for word. When you get out in the real world and you're working with buyers and sellers, you need to be familiar with the contract. So day one today is just an introduction, easing you in, the beginning of many. Questions so far on our guidelines? Before we look at our offer to purchase and contract, I need to continue off book for a minute, because I have found there are some provisions in the contract that I believe we need to hear more than once so it can click, so we can better understand it. So before we jump into the contract and see them, I'd like to take a few minutes and introduce you guys to some of these provisions, start getting an understanding of some of the provisions that we're getting ready to see. And specifically, what I would like to go over with you to begin with, before we look at our contract, is something called a due diligence fee, something called a due diligence period, and something called an earnest money deposit. And we're going to talk about what all three of these things are, what they do, and what they mean before we actually look at our contract, before we go in and check it out and see where it is in the contract. So we're going to talk about the DDF, the DDP, and the EMD. There's your acronyms. If we can make it, we can do it. DDF. So first off, understanding just our vernacular, our verbiage. Most of the times when you're referring to a deposit, you're referring to money that is refundable, may be refundable. Generally speaking, a fee is not refundable. There's exceptions to both of these, and we will see them. But in general, A deposit is oftentimes refundable if we terminate. A fee is not. The first part of this discussion is what happens if we terminate. We will get to closing in a second, but unfortunately, you guys, not all of them close. So we have to talk about deposits and fees. I'm going to go back for 1 second. We're going to learn there's a due diligence fee and there's an earnest money deposit. Both are negotiable amounts, which means the buyer and the sellers have to agree on how much the due diligence fee will be. They have to agree on how much the earnest money deposit will be. The contract tells us what happens to this money. The parties agree on the amount. It's a negotiable item. It's a blank in the contract that we have to fill in based on their counteroffers, based on their offer and acceptance. So we're going to talk first about the due diligence fee, due diligence period. Again, this answers the question, what happens to these monies if we terminate? So first off, we have something called a due diligence fee. As we said, this is a negotiable amount, and upon contract formation, the due diligence fee is paid by the buyer to the seller directly. The buyer is going to write a check to the seller for the due diligence fee. We go under contract. The buyer's paying the seller. Why in the world would the buyer pay the seller? The buyer pays the seller the due diligence fee for their right to terminate. There's a period of time called the due diligence period. The due diligence period is the buyer's opportunity to learn as much about the property as they possibly can. Inspections, investigations, surveys, research. It's their opportunity to learn as much about the property as they possibly can, and then decide, now knowing what I know, do I want to terminate or proceed with this transaction? The buyer gets, I can't call it a free look because they have to pay for it, but the buyer gets an opportunity to look and then make the decision. And that's what we're going to learn about with the due diligence period. The due diligence period is also a negotiable amount, or excuse me, it's a negotiable amount of time. Is it going to be a day? Is it going to be a month? How much time does the buyer get in their due diligence period? Because this is a fee, if the buyer exercises their right to terminate, the seller will keep the money. That's what the buyer's paying for. They have this period of time that they can terminate. The seller's been paid for that right to terminate. So if the buyer exercises their right to terminate, the seller can't take them to court. They accepted money for that right. Who can remind me what caveat emptor is? What does caveat emptor mean? I'm seeing mouths move. Remember, buyer beware. The seller doesn't have to disclose anything. So isn't it only fair to the buyer that we give them an opportunity to learn? If the seller doesn't have to say anything, isn't it only right that the buyer has the opportunity to learn and make a decision? And that's what the due diligence period is for. So buyer pays the seller due diligence fee. If the buyer terminates within due diligence, then the seller keeps the due diligence fee. It's a non-refundable. So buyer exercises their right. We're still in due diligence. The buyer did their home inspection and they decide there's too many problems that they don't want to deal with. I don't want to fix the roof and the electrical and the plumbing. I want out. The buyer exercises their right within due diligence. They terminate. The question is, do they get their due diligence fee back? And the answer is no, because that's what the buyer paid for. The buyer is paying the seller for that right to terminate. If the buyer terminates after due diligence, we could be hours away from closing and the buyer terminates, because this is a fee, it's going to be very rare that the seller has to give it back. Fees are generally non-refundable. We have a few exceptions that we will address. I'll go ahead and tell you right now. If the seller terminates, they do not get to keep that money. That would be one time that the buyer could get their due diligence fee back. But if the buyer terminates, whether we're in due diligence or after due diligence, the seller keeps the fee. Fees are non-refundable. So we've got under contract, the buyer wrote one check to the seller on the agreed amount for the due diligence fee. They're going to write another check once we have contract formation. They're going to write another check for the earnest money deposit. Earnest money deposit is also a negotiable amount. The parties have to agree to it. And the whole point of the earnest money deposit is to show the seller that the buyer really wants to buy this house. The seller wants to know that they have a serious buyer, not just somebody out there kicking the tires, playing around. Put your seller hat on. Has anybody ever sold a house before? Once you agree to sell the house, don't you have to go live somewhere else? Don't you have to find, maybe you have to go under contract to buy a new house, or you have to sign a lease. The seller needs to know that when they're moving on to that next phase, that this is a serious buyer. And one way the buyer can show that they're serious, show their good faith, is with the earnest money deposit. The earnest money deposit is made out to the escrow agent. The escrow agent is either the real estate firm or the closing attorney, whomever has the escrow account. We're going to talk about the escrow account that's coming at the end and license law and commission rule. What we need to know about it right now is that it's an account by an impartial third party. We're not going to let the seller hang on to it. We're not going to let the buyer hang on to it. We're going to let this third party escrow agent hang on to it, keep it fair between the parties. So contract formation, buyer's writing two checks, one to the seller and one to the escrow agent for the earnest money. The earnest money sits in the escrow account during the contract to closing process. So now the question on the table is, if the buyer terminates, do they get their earnest money deposit back? We've already decided they're not getting their due diligence fee back. But if the buyer terminates, will they get their earnest money deposit back? And the answer is, it depends. It depends on when we terminate. If the buyer terminates during their due diligence period, they will get their earnest money back. The buyer is not considered in breach until after the due diligence period, because that due diligence period is the buyer's free look period, the free look period that they have to pay for. So the due diligence period is the buyer's right to terminate, specifically for any reason or no reason at all. They could get the home inspection back with lots of problems, say, I don't want to deal with it. Y'all, they literally could wake up the next day and go, nah, I don't want to buy this house. For whatever reason, if they terminate within due diligence, they will get their earnest money back. If the buyer terminates after due diligence, now the buyer is in breach. The seller will still keep the due diligence fee, and now they will also get the earnest money deposit. Timing, just like money in the contract, is negotiable. So we may have, generally speaking, we have a week or two between due diligence and closing. So we've moved past due diligence. We're getting closer and closer to closing. Again, we'll go through that contract to closing process. But as we get closer and closer to closing, the seller has more to lose. Again, they got to be under contract to buy another house, or they have signed another lease. Put yourself in the seller's shoes. Guys, there have been cases where the buyer never shows up to closing. They just disappear. They ghost everyone. What's the seller left with? Well, a big empty house and all their stuff in a moving truck, right? The seller needs to know that if the buyer never shows up to closing, that they got something. And what they got is the due diligence fee. And if we terminate after due diligence, then the earnest money deposit will go to the seller. So to recap real quick, we're going to see it again in the contract. If the buyer terminates, the seller will keep the due diligence fee. Buyer terminates, seller keeps the due diligence fee. That's what the buyer pays for. If the buyer terminates within due diligence, they get their earnest money back. If the buyer terminates after due diligence, then the earnest money goes to the seller. The buyer is not in breach until after the due diligence period. In the event of buyer breach, the seller will keep the due diligence fee. They'll get the earnest money deposit. And the two together are referred to as the seller's liquidated damages. We just defined liquidated damages in Unit 9 as money damages that we agree to at the time of contract formation. The parties agree to the due diligence fee. They agree to the earnest money deposit. The seller's liquidated damages are the seller's sole and exclusive remedy in the event of the buyer's breach. In other words, that buyer that never showed up to closing, all the seller gets is the due diligence fee and the earnest money deposit. Sole and exclusive remedy. The seller can't take the buyer to court. Liquidated damages says this is it. So listing agents, when you start getting those offers in, I need you to make sure that your seller is comfortable with these numbers and make sure they understand this is it. That buyer never shows up. This is all you get.
Miss Julie, I noticed when I sold my house 2 years ago right after COVID, the
Good times.
yes, it was the best time. That's the only reason why I did it, but it was bad time to buy. So for me, after I sold, but the due diligence, one of the cash buyers offered me $25,000 in due diligence. And that was really nice. But I noticed I knew he wasn't going to back out if I accepted.
That's a lot of money to put up. And Lynn, you don't have to answer, but I mean, is that the offer you took? Is that the offer you accepted?
I did, and I got over $125,000 after my house was paid off.
And I imagine, because I'm thinking in that time of year, you were in a multiple offer situation. And the reason, part of the reason you accepted that offer is because your agent looked at you and said, that $25,000, that's made out to you and you get to keep it. And you probably went, where do I sign? Because I've never seen a check made out to Julie Campbell for $25,000. I'm sure that was a very exciting day, right? Due diligence fee, money talks, you guys. Can we agree with that? Put real estate aside. Money talks really loud. And to the seller, especially in Lynn's situation, in a multiple offer situation, money such as the due diligence fee or the earnest money deposit talks. To Lynn's point, she felt comfortable that that buyer was going to buy, because putting $25,000 down, it's hard to walk away from that. Can we agree with that? Walking away from $25,000. So she felt more secure with this buyer because they were willing to put more down. They had more to lose. What if the buyer offers you 50 bucks? How do you feel about that, right? It's all negotiable. And a lot of it depends on the market. You know, a couple years ago, due diligence fee and earnest monies were absurd. I mean, $25,000 is a lot. I heard of six-digit due diligence fees. Now, these are higher end properties, and I don't know where they're getting that kind of money. I say good for them. But, right, as we get more and more into a buyer's market, we're seeing that come down because it's all a matter of the market, who's in control, who's driving. Thank you for sharing that. Buyer breach after due diligence. The buyer's in breach after due diligence. The seller's liquidated damages are their sole and exclusive remedy. What happens if the seller breaches? If the seller breaches on day one, or if the seller never shows up to closing, no matter when the seller terminates, the buyer can sue the pants off them. They can take them to court for compensatory damages. They could go after specific performance. The buyer could sue the pants off of the seller if they want to. Breach for seller is much harsher than it is for the buyer. The buyer just loses due diligence and earnest money. The seller could lose the property, specific performance. The reason being why seller breach is much harsher for the seller than it is for the buyer. Breach is much harsher for the seller than the buyer. The seller is the one that initiated this whole thing to begin with by putting a for sale sign in their front yard. And the thinking is if they really didn't want to sell, then they should not have started this by advertising and marketing their property for sale. So again, when you're with your sellers at that listing appointment, and I know it sounds funny to say, but you need to make sure that they're serious about selling. Because once we're under contract, if they change their mind, the buyer could sue the pants off them. I had sellers once, and they were so ready to go, we couldn't get a buyer fast enough, and they were willing to fix everything and repair everything. I mean, they were just wanting to sell so bad so they could move on to the next phase of their lives. They called me one morning or one afternoon, whatever, and said, guess what? And I said, what? And they said, we're pregnant. And I was like, oh my God, that's awesome. Good for you guys. And they said, we changed our mind. We don't want to sell our house. I said, you guys need to understand the consequences of your breach. If you terminate, the buyer can come after you. Y'all need to talk to your attorney to better understand those consequences. In the end, they sold, but I'm telling you, they were not happy about it. The point here is that you can't change your mind. That's not the way. And I understand there's always the, what about this? What if? But it is a legally binding agreement with teeth. And these are the teeth. The teeth are what happens if either party breaches. So no more doom and gloom. They don't all terminate. Sometimes they actually close. So what if we actually get to make it to closing? What happens to those monies? If we make it to closing, the due diligence fee and the earnest money deposit are going to be credited back to the buyer. They've already paid that money once. And now that we're at closing, they will have that money deducted from the sales price. So if we actually make it to closing, the due diligence fee and the earnest money deposit will be credited back to the buyer. The due diligence fee is going to be a debit from the seller. Unit 21, we go to closing. And part of going to closing is understanding the buyer's debits and credits and the seller's debits and credits. Both parties' debits and credits help us understand, help us calculate how much does the buyer have to bring to closing and how much is the seller going to get. So that's the kind of fun math we have to look forward to in 21. More on debits and credits. So again, just a very brief introduction to some of these ideas, due diligence fee, earnest money. We're going to see all this defined when we look at our sales contract in just a minute. But it just goes, it supports what we've been saying, that these sales contracts have teeth and they have to spell out what happens if either party doesn't do what they promised to do. If either party breaches, what happens? And that's where our due diligence, our earnest money come into play. Questions so far? So now where we're heading, we're going to go off book for quite a bit. And we're going to go specifically look at our offer to purchase and contract standard form 2T that's in the online learning system. Before we go there, as a reference, when you guys are studying, look with me on page 290. How about 293? In 293, the whole way over to 304. 293 to 304. These are the terms of the sales contract, of offer to purchase and contract standard form 2T that we're going to see, but the pages in your book give you an explanation. They give you a better understanding. So kind of like with our agency agreements, the suggestion is that you go through those pages in your book with 2T in your hand so you can see those provisions. You can parallel those provisions. So use your book as a reference. Use your book as a guide to help you know what to focus on in 2T for your exams. And with that being said, we're going to go to the online learning system. And I'm in the Julie folder. And under the Julie folder, we have 2T, offer to purchase and contract. And this is the current one. They just updated it again in July. So never the one in your book. Always go to the online learning system. Everybody with me? We're in the Julie folder. And we're going to look at our offer to purchase and contract 2T. And guys, we're going to be here for a while. Again, not going through it word for word, but talking about these provisions. So you have that to reference those pages in your book. Good enough? Are we all on the same page-ish? Perfect. So let's make this big where we can see it. And we're going to look at the offer to purchase and contract. First off, the name itself implies that it's an offer to purchase, and upon acceptance, it becomes a legally binding contract. So North Carolina, our sales contract state. The first provision of the offer to purchase and contract are terms and definitions. We're going to spend the first, 2.5 pages defining things, defining various terms and definitions. At a minimum, I think you guys should look at this because a lot of this defines things like due diligence period, earnest money deposit, things like that we're getting ready to look at. So first off, the first thing we're going to define is who are the parties to the contract. Sales contract is between the buyer and the seller, and it's not any old buyer or seller. We're looking for specific names. I need the legal first and last names of all sellers and all buyers. Don't Mr. and Mrs. them. Everybody has their own legal name. So we need to spell it out. Who the parties are, the buyers and the sellers. For sellers, we need everybody on the deed and their spouses. Remember, everybody's got to show up to sign on closing day. For the buyers, we need everybody that's going to be on the deed. Up next, we're going to define the property. So the property that this contract is for, it asks us, it will or will not include a manufactured or mobile home, will or will not include an offsite or separate septic lot, slip, garage, parking space, etc. Defining the property. We have a place for the street address, city, zip, and county. Because the sales contract is a document used to convey. I'm conveying real estate from the seller to the buyer. Anytime we're conveying property, the street address alone is not sufficient. We're off to a good start, but I need more than that. So now we have a place to fill in the legal description, and we're told here to complete all applicable. And this is where we're looking for the subdivision name, the tax ID, deed book and page, all of that research you're doing to fill in the blank, that GIS system we mentioned, again, all that comes from your firm when we get there. But we need to fill in as much as the legal description, in addition to the street address that we can. So everybody that is involved in this transaction knows exactly what property it is we're talking about. So legal description, because we're using to convey. And then we need to define the purchase price and how it's going to be paid. Let me try and get this where we can, well, we'll have to do it this way. So I got a bunch of lines there with dollar signs. Some of these lines will be used. None of them are going to be used. You're never going to have a transaction where all of them were used, right? So in the case that we have a transaction when they're not used, remember you guys, never leave a blank blank, especially when it comes to money. Don't give somebody else the opportunity to put an amount here. So if we're not going to use these blanks, indicate as such by putting a 0 in there. So let's go through from top to bottom and talk about what each blank means, and then we'll put it all together. So the first blank is the purchase price paid in US dollars upon the following terms. The purchase price is what the buyer is willing to pay for the property, what the seller is willing to sell the property for. This is the sales price. What are you going to buy my house for? The second blank is our due diligence fee, X amount, negotiable amount, made payable and delivered to the seller on the effective date. We're going to define that effective date in just a second. And then the terms. How is the buyer going to deliver that due diligence fee to the seller? Am I going to give you cash, personal check, wire transfer, etc.? And then I have two blanks for earnest money. One is initial earnest money. The other one is additional earnest money. They're both earnest money. They both do the same thing. The difference is when are they due? Initial earnest money is made payable and delivered to the escrow agent within 5 days of the effective date. And then how are we going to deliver that? So the initial earnest money is due initially upon contract formation. We have 5 days to get it there. Additional earnest money typically comes later if we have it. Sometimes you do, sometimes you don't. All negotiable. Remember, every transaction is different. Additional earnest money is made payable and delivered to the escrow agent no later than 5 p.m. And here is the first time that we see time is of the essence. This additional earnest money is due by 5 p.m. on this date. Time is of the essence. If the additional earnest money comes in at 5:01, it is late and the seller may terminate. That's what time is of the essence means. It's pretty dang specific. Drop dead date and time. And again, the terms on how that earnest money will be delivered to the escrow agent. It's all negotiable. So there's no wrong way to do this. Sometimes we see initial and additional. Sometimes we just see initial. Sometimes we just see additional. It's whatever the parties agree to. All part of that negotiations. So we're going to spend some more time on earnest money, more time on due diligence in just a second. We may have a loan assumption. In a loan assumption, the buyer is assuming the seller's loan. They're taking over the seller's mortgage payment. They're taking over their responsibilities. More on that coming in our financing units. We may have seller financing, where the seller's acting as the banking institution. We're going to buy, and then the buyer's going to pay the seller directly. If it's new construction, we might have a building deposit. So again, various situations may require some additional monies here. One thing I like, there's so many things, our contract it's really good, you guys. And one thing I like about it, when a need comes up to use an addenda or an additional form? My contract tells me. So I don't have to guess. When do I need the seller financing addendum? My contract tells me if we're doing seller financing, I need the addendum, and oh yeah, there's the form. So we can use the contract to not only make sure we get all the addenda, but also to help us know what addenda we need to add to make it part of this offer to purchase and contract. Another good case for being familiar with the sales contract, so we know what we need to add to it. Again, I mean, I don't know. I don't like the word never, but you know what? If you ever get in a situation where you use every single one of these blanks, I need you to call me because I got some questions for you. It's going to be, 20 years down the road, call me. I don't care. I don't know that you're ever going to see a situation where every single one of these is used, but it's all part of how that money is paid towards the purchase price. So again, if you're not doing seller financing, then we're going to plop a 0 in there. If you're not doing loan assumption, 0, new construction, 0. We're just identifying these blanks as they relate to that. I got that off, but so let's run through. And then the last line here is the balance due. So let's say we have a purchase price, I'm making numbers up, of 100,000. And let's say Lynn is our seller and she needs a due diligence fee of $25,000. And then she doesn't care as much about the earnest money. So maybe we just negotiate 500 initial and 500 additional. Lynn cares about the due diligence fee that she can put in her pocket today. Fair enough. We don't blame Lynn, do we? As the seller, let's get this money now. So we've agreed to these terms. This was negotiated a back and forth. Thank you, Lynn, for picking. The top line, the 100,000 minus all the lines in between. The difference then is going to be the balance. The buyer's already paid $25,000 in due diligence. The buyer's paid $1,000 in earnest money. So if we get to closing, the balance of the purchase price in cash at settlement, some or all, which may be made with the proceeds of a new loan. So the buyer, as long as we get to closing, the buyer's kind of prepaid some of these things. Let's think of that as a prepay if we get to closing. So the top line minus everything in between gives us the balance. We're contractually obligated for a purchase price of $100,000, but I've already given you 35. So now I only have to bring $65,000 to closing. Defining due diligence, defining our earnest money, effective date, some of these other terms on this page. We're going to do that next. Any questions on filling out this piece with the money, making sure these are all negotiable items? Questions on this? By the way, always keep in mind, you guys, these fields, due diligence and earnest money. Did I not do my math right? 74,000. Okay. So whenever we're doing, whenever we're filling these blanks in and we're doing negotiating due diligence fee and earnest money, it's a completely negotiable amount. The real estate commission, there's no formula. And a lot of times as brand new agents, we look for a formula. We want help. How do I know what to put in here? The real estate commission, y'all want to know what the real estate commission tells us? The due diligence fee and the earnest money are negotiable. It's whatever the buyer is willing to offer and the seller is willing to accept. Please don't go into this industry thinking you can have a formula. It doesn't work that way. As we just said, it's negotiable. It may depend on the market. When we get back into a buyer's market, you're not going to see $25,000 in due diligence fee. The only reason we saw that is because we were in a strong seller's market. Does that make sense? So there's no right answer to this. Technically, if the buyer offers 0, and the seller accepts 0. Congratulations, folks. We are under contract with a due diligence fee of how much? 0. Completely negotiable, whatever the buyer is willing to offer and the seller is willing to accept. Questions? Bottom of page 1, 17. Like I said, we're going to be here for a while. I believe we saw this in our listing agreement, but again, it just kind of goes to show any form from NCAR, the bottom of the first page is going to give us some information. Because I'm a member of the National Association of Realtors, I can rock this capital R. If you're not a member, if you're not a realtor, you can't use these pre-printed forms. Whether or not you join NAR is going to be up to your firm. If your firm's a member, you have to join. If they're not, then you don't. It's like that. If your firm isn't a member of NAR, then they will have their own set of pre-printed forms. But we can rock these because I'm a member of NAR. This form is jointly approved by, here's the North Carolina Association of Realtors and the North Carolina Bar Association. So who's preparing our sales contract? Attorneys, active members of the Bar Association. NCAR and NCBAR get together and create our forms for us. There's our equal housing opportunity logo, telling us that we will provide equal housing for all. More on that, Unit 19. And then our standard form 2T, and it tells us when the most, what revision we're using. I know this goes without saying, but from the voice of experience, please always make sure you're using the current form. It's a lot easier these days with electronic, but just make sure you're always using the current form. Moving on to page 2, I'm not going to spend a lot of time here, but this first paragraph here answers the question. What happens if the due diligence and earnest money are late or if those checks bounce? So first, if I may go back up, the contract tells me when they're due. The due diligence fee is due and payable on the effective date. The initial earnest money is due and payable within 5 days of the effective date. So what if the buyer doesn't deliver these on time? Or there have been cases where the buyer delivers them on time, but guess what? Those checks bounce. So this paragraph is addressing that. And the big thing to know here is if they're late or if they bounce, the buyer's going to have one banking day to deliver the funds. The seller sends written notice that they bounced or they're late. The buyer has one banking day after written notice to deliver that money. And in the event that they don't do it on time within that one banking day, the seller shall have the right to terminate. So by that money being late or by those checks bouncing, we're giving the seller not. Now that says shall have the right. So that means the seller has to terminate? They have options now. They could choose to walk away. Now we're defining things. Again, still on that first provision of terms and definitions. The earnest money deposit, whether or not referring to initial earnest money or additional earnest money. Earnest money is paid or required to be paid in connection with this transaction. It's going to be deposited and held in escrow by an escrow agent. So the escrow agent will hang on. Again, it's an impartial third party that's holding this money on the people's behalf. The earnest money deposit will be credited to the buyer at closing or dispersed as discussed later in this contract if we don't make it to closing. Then we define the escrow agent. We can't just say it's going to go to an escrow agent. We all have to agree on who. Some real estate firms will manage an escrow account. Others do not. If you do not manage it, if your firm doesn't manage an escrow account, then the closing attorney can act as the escrow agent. So we need to know, is the earnest money going to go to the firm, the real estate firm, or is it going to go to the closing attorney? We got to put the name of the firm in here, not the individual agent or not the individual attorney. So the escrow agent is the name. That blue note there is talking about what happens if the earnest money goes into dispute, if we terminate. If we terminate, even though we'll see in a minute that the contract is very clear about what happens to the earnest money. If we terminate within due diligence, the buyer will get their earnest money back. If we terminate after due diligence, and it'll go to the seller. We're going to see all that spelled out in just a second. However, if we terminate, that money doesn't go to the appropriate place automatically. The parties have to agree to release it. Remember that escrow agent is an impartial third party, meaning they can't make the decision about what happens to that money. So we terminate, somebody refuses to sign to release it. Now that earnest money is in dispute. The escrow agent cannot make a decision. They hang on to that money for X amount of time, make several attempts to try to get the parties to agree. But in the end, the escrow agent has the option to deposit that disputed earnest money to the clerk of courts and let the two go downtown and hash it out. They can't make the decision about what happens to it. But you know what? The clerk of courts can. So if we terminate, we got to get everybody to sign, or else that money is in dispute. Questions? All right, let's take 10. We come back, more terms and definitions. Welcome back. While we were at break, I went ahead and put that link for Parade of Homes this weekend if you guys didn't grab it last time. And hey, if you're not able to get the link from the chat and you want to go to Parade of Homes, just shoot me an email. I'll be happy to send it to you. So we're back. Cameras are coming back on, and I can see you. So I'm going to take attendance. Do I have you guys? Are you guys here? My screen's like jumpy. Am I jumpy on your end? A little bit? No? Looks like it just depends on where we are, right? It's amazing to me how Zoom, think about all of our internet connections, think about all of our devices, and somehow Zoom can bring us together. I can't even fathom how that works. So thank you. Okay. Offer to purchase and contract. We talked about the escrow agent. Now let's define the effective date. The contract defines the effective date as the date, one, that the last one has signed this offer or final counter offer, and two, such signing is communicated to the party that makes the offer. So our contract tells us our magic moment in time is once we have the last offeree signs and communication of acceptance crosses the line to the last offeror. That's when we have contract formation, and that's referred to as the effective date as the contract. In other words, what date did this contract take place, take effect? Most of the time, the last offeree signs and communication of acceptance crosses the line on the same day. So we have the effective date whenever that happens. But what if we're up late one night and throws in negotiations and you tell me your guy signs at 11:30 at night, and I don't communicate that until my guy at 6 o'clock the next morning? In that case, the effective day would be tomorrow morning. It would be tomorrow because we need both of those events to happen. Everybody with me? You signed today, but we didn't communicate that acceptance until tomorrow. Again, communicating is so very important. Make sure we're effectively communicating. As we just had an example of another buyer swooping in with a better offer, and those buyers were out. So just make sure we're effectively communicating. We're all on board for that effective date. Make sure there's nothing there that we need. Then we're going to define due diligence fee, and on the next page, the due diligence period. So let's start with defining due diligence. Due diligence is defined as the buyer's opportunity to investigate and inspect the property, or the opportunity to investigate the property, to decide whether the buyer, in their sole discretion, will proceed with or terminate this transaction. This is a result of caveat emptor. If the seller doesn't have to disclose, isn't it only fair that the buyer has the opportunity to learn? And that's what the due diligence period is for. It's the buyer's opportunity to investigate the property. And then they have a choice to make. Now, knowing what I know, do I want to proceed with or terminate this transaction? Sole discretion. The due diligence fee is a negotiated amount, if any, Again, I offer you 0 and you accept 0. We have a legally binding contract with 0. So negotiate about if money paid by the buyer to the seller. And the whole reason the buyer's paying that due diligence fee is for their right to terminate for any reason or no reason during the due diligence period. The due diligence fee, the buyer pays the seller for the right to terminate. And if the buyer exercises their right to terminate, the seller can't go after them in court because they accepted the due diligence fee. Yeah. Have a question? There's a very common misconception out there. And the common misconception is that the buyer's paying the seller for the seller to take their home off the market and not allow any more showings. The seller, once we have a contract, the seller can still choose to allow showings. They don't have to stop showings. They could still leave the property open for viewings. The seller could accept a backup offer from another buyer. So let's debunk that myth. That's not what due diligence fee is for. The buyer's paying the seller for the right to terminate, specifically for any reason or no reason during the due diligence period. Again, they could find a whole lot of issues in the home inspection and decide they don't want to deal with it. This is too much for me. I don't want to take this on. I'm going to terminate. They could wake up tomorrow and change their mind. This is what we mean by any reason or no reason. They will lose. They're not going to get their due diligence fee back, but they're no longer contractually obligated to buy this property. What questions do I have about that? Goes on to say that the due diligence fee is going to be delivered to the seller upon the effective date. It also goes on to say that it's going to be a credit to the buyer at closing. It is non-refundable, except in a few situations. One of those situations would be breach of this contract by the seller. So if the seller breaches, they do not get to keep the due diligence fee. If the seller breaches, then they have to give that money back. And if they're not willing to give it back, then the buyer can take them to court. This is part of those compensatory damages. We got some bad connections. I see some of you. Some of you look stuck. Are we here? Can you guys see me, hear me? Okay. All right. Good, 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 good. I don't know what's going on. All right. Due diligence fee. And then we have the due diligence period. So I got two different options here for the due diligence period. Either I'm going to put in a specific date. The period beginning on the effective date, which we just defined, extended through 5 p.m. on this date, or the period extending for a number of days. So we could use like 15 days or 30 days, whatever the parties agree to. The due diligence period is our second. Time is of the essence that we see in our contract. The due diligence period is a drop dead date and time. The buyer can terminate at any point up until 5 p.m. on this date and get their earnest money back. At 5:01, they are in breach if they terminate. At 5:01, if they terminate, then they lose their due diligence and their earnest money. Breach of contract is when either party does or does not do what they promise to do, when they don't fulfill their terms, their obligations, their responsibilities that are spelled out in the contract. I promise you I'm going to buy, and then I don't, I'm in breach. You promise me you're going to deliver clear marketable title, and then you can't, you're in breach. We're going to see those duties and obligations spelled out. Questions on due diligence, the monies, the period, what the buyer's doing. Then we're going to define settlement, settlement date, and closing. And we got to see a distinction here between settlement and closing. We all call it closing. We say we're going to go to closing. We're going to meet your buyers and sellers at the closing attorney's office. Any of you ever bought a house or sold a house before and you went to closing, or so you thought? I got a confession to make, you guys. In all my years, I've never been to closing. And guess what? You haven't either. If you bought or sold, buyers, sellers, what we attend at the attorney's office is settlement. Now, when you get out in the real world, you'll refer to it as closing as well, I promise. But until you get out in the real world, I need you to see that settlement and closing are two different things. Settlement is the execution and delivery to the closing attorney of all documents necessary to complete this transaction. The buyer has paperwork to sign, the buyer has paperwork to sign, the seller has paperwork to sign. Settlement is when the attorney is gathering both sides' paperwork, both parties' paperwork. In addition to that paperwork, the attorney is also collecting all funds necessary to complete this transaction. So the buyer's generally going to have money to bring to settlement. If the seller owes, if they're underwater and they owe more than what the property's worth, and they may need to bring money to sell as well. So settlement is when we go with our clients to the closing attorney's office for them to sign everything and bring their funds, bring their monies. And we're going to agree, we're going to negotiate the date that settlement will take place on. Settlement date. Generally, we give ourselves a week or two or four, whatever, from the time due diligence ends until settlement. And that gives everybody an opportunity to kind of put the finishing touches on things. If we agreed upon repairs, we'll talk about that in a second. If we agreed upon repairs, we got to give the seller time to do those repairs. You're probably not going to see due diligence and settlement on the same day. So we usually have a period of time, a week or two or whatever in between. And we all agree on when we want to go to settlement. Note here that the due diligence period is a time is of the essence. We have a drop dead date time for due diligence. There is not a time is of the essence on the settlement date. Settlement or delays in settlement just happen. There's so many things that can cause a delay in settlement. We put this date in the settlement. This is the date that everybody's trying really hard to work towards. In the event that we can't close on settlement, we're going to see in just a bit that the contract has a delay in settlement clause built right into it, because delays are just so common. And I can't tell you what's going to cause this settlement to be delayed. I don't have a crystal ball, but I do know that delays are common. So in practice piece of advice, always have your buyers and sellers have a plan B. I'd like to think that we're going to go to settlement today, but things happen, you guys. Things happen. So let's have everybody have a plan B in place just in case we have a delay in settlement built into our offer to purchase and contract. Then we define closing. So closing is the completion of the legal process. Who does the legal process? The closing attorney. So once we all leave settlement, we go in and do our thing, and then we leave, and then the attorney proceeds with closing. Closing is defined as the legal process that includes settlement that we defined above, the completion of a satisfactory title update. The attorney is going to make sure that the title is up to date and good. The closing attorney's receipt to disperse all necessary funds. So this is when the lender will send their money in on behalf of the buyer. And then the very last act of closing, the very last thing to happen, number 4, recordation of the buyer's brand new deed and the deed of trust if their attorney is involved. Then and only then is it a done deal. That's worth me saying again. It's not a done deal until the buyer's new deed has been recorded. So if we leave settlement and then the attorney finds an issue with the title, they can't record. If we leave settlement and something happened, the funds get intercepted, maybe the hacker got involved and the funds got intercepted, it's not a done deal until the buyer's brand new deed is recorded at the Register of Deeds, showing that they are now the owner of record. Nobody, including you and I, gets paid until that brand new deed is recorded, because we don't get paid until it closes. And the last act of closing is recording that buyer's new deed. So usually what happens, all attorneys are different. Sometimes they record in batches. Maybe they'll record at the end of the day or something, you know. But usually, in general speaking, what happens is we go to settlement with our buyers and sellers, and then we leave. And then we later get a call from the attorney or the paralegal or an email. And it's my favorite email in this whole industry. Short, sweet, and to the point. And that email says, "We are on record." And that's what I need to know, that it's done and I can go get my check. It's not a done deal until that deed gets recorded. Settlement and closing often happen on the same day, but if something comes up, they may not. We're going to see the buyer should not get possession until it's theirs, until that deed is closed. They shouldn't be given access to the property, keys or garage door openers, until that deed has been recorded. So again, seeing that difference between settlement, what we do with the attorney, versus what the attorney does when we leave, and finalizing that process. Questions on this? This warning is just reminding us, North Carolina, in North Carolina, we are an attorney closed state. So in North Carolina, closing needs to happen as practice of law. It's going to be an attorney closed state. We'll compare that to other states in future units. Some states don't use attorneys. Some states use the title insurance company. So we'll see that. The entire contract to closing process is in Unit 21 for us. So we'll walk through from the time we go under contract to the time we close when we get in 21 and talk about the different types of settlements. But in North Carolina, we're an attorney closed state. So we do use closing attorneys, also known as settlement agents. And then the last thing here we're defining is that special assessment. We've talked about special assessments charged by a government authority. So think like maybe the government, maybe they're installing sidewalks or hooking a whole neighborhood up to public water or sewer. You may also have a special assessment through the HOA. So maybe the condominium community is repaving the parking lot or something, and the HOA puts a special assessment out. All we're doing right now is defining a special assessment. Later in the contract, we're going to see specifically what is the buyer's responsibility with special assessments and what is the seller's responsibility with special assessments. So just defining it for now. 2.5 pages of just terms and definitions, going through and defining various things. At a minimum, I think you guys should be familiar with these terms and definitions because they're good testable points. So if you don't want to do anything else with the contract, focus in your book. I get it. It's a lot, you guys. So break it down into small chunks. But at a minimum, I suggest being familiar with the terms and definitions, having that understanding of the due diligence fee, the due diligence period, and the earnest money deposit, and how that works. What questions do I have about those terms and definitions? Second provision is talking about fixtures and exclusions. So once again, we see that fixtures list that we saw in our listing agreement. Remember when we were talking with the seller and I need to know anything that you're going to take because we need to let the buyer know, or we need to have you take it before the buyer shows up. That exact same list, word for word, shows up in our offer to purchase and contract. If we're using standard offer to purchase and contract 2T, then these things are considered fixtures. If you're using a different sales contract, then the fixture list may look different. So the fixture list isn't any kind of standard set across the board. It's generally per contract. If we're using 2T, these things are considered fixtures. And if the seller is going to take any of the fixtures, then we have a place we have to spell out other items that do not convey. So any fixtures that the seller has not already removed before you listed, anything that the buyer may see that the seller is going to take, we have to put that in the contract. Remember, our parole evidence rule says the final written word of the contract shall prevail. We also have a place for any items that are leased or not owned. The seller can't convey what's not theirs. So if they're making payments on something, if they don't own it yet, then they're not, we have to identify it here and figure it out. Maybe the seller can pay it off. Maybe the company that's leasing the equipment wants it back. Maybe it's not transferable. All we're doing right now is identifying those things that are leased or not owned, and then identifying the things, the fixtures that do not convey. This verbiage here just makes sure that the seller, if they do rip the ceiling fan out of the ceiling, they don't leave a big hole. They repair any damage caused by removing those fixtures, by removing those things that they're going to take with them. The opposite of fixtures then is personal property. If the seller is going to leave personal property, we've got to spell it out here in our contract. Remember, a fixture is meant to stay. Personal property is meant to go. If these things are ever going to do the opposite of their intent, they need to be spelled out in the contract. Fixture stay, personal property go. If you're listing fixtures or personal property, be specific. You know, if you're the buyer's agent, you're the one filling this in on behalf of your buyer. Don't put fridge. Tell me specifically what fridge your buyer wants. 2-door, stainless steel, Whirlpool. Sometimes you can get like model numbers, things like that on the inside doors when you open the fridge. The problem with putting just fridge, there have been cases, you guys asked about court cases in the past if this actually happens. There's been court cases in the past where the buyer asks for the fridge. And when they show up after closing, the seller has left in the place in the kitchen the seller has left the 2-shelf dorm room refrigerator. Did the seller do what they were contractually obligated to do? Did they leave a fridge? Yeah, they're fine because the final written word shall prevail. So make sure when you're asking for that fridge, that personal property for your buyer, is it still going out? That personal property for your buyer, that you're specific about what refrigerator it is. You know, somebody mentioned the beer fridge earlier. Some people have the main refrigerator in the kitchen and then they got the beer fridge in the garage, right? If you put fridge, they could leave you the beer fridge and say, well, there you go. And I doubt they would leave the beer in it. They're going to leave you an empty beer fridge. So just be specific when we're asking for these fixture exclusions and personal property inclusions. Questions about fixtures or personal property? Then we're going to break this down. We're going to break the contract down and talk specifically to the buyer, talk specifically to the seller. We've been talking a lot about each party's duties and responsibilities. So we're going to break this down. You may want to make a note to help you in sorting this thing out. Again, it's 17 pages. It's overwhelming. I get it. So try to break it down, try to simplify it. Make yourself a note. Provisions 4, 5, and 6 are all about the buyer. So as a buyer's agent, those are the ones you care about, 4, 5, and 6, because those identify what the buyer's responsibilities are, what the buyer's obligations are. Somebody asked earlier, what's breach? As a buyer's agent, this is what we need to make sure that the buyer understands. This is your duty. This is your obligation. And if you don't do it, you could suffer the consequences of breach. So specifically, number 4 is addressing specifically to the buyer's due diligence process. And this thing starts with a big red warning, which is meant to attract our attention, not overlook it. And we say the buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results of their due diligence, then they should terminate this contract prior to the expiration of the due diligence period. Remember, as long as they terminate within due diligence, they have exercised their right to terminate. If they terminate for any reason after due diligence, now they're in breach. So as a buyer's agent, I don't want my buyer to breach. So if we have to terminate, we must do so within due diligence. That's the only thing I can do to get my buyer their earnest money back. Unless the buyer can obtain a written extension from the seller, we can always ask for more time. Anything is negotiable, you guys. Even though we're under contract, everything is still negotiable. So we can ask for more time, but the seller's not obligated to grant that extension. The most I can do, the least I can do is ask. You know what's one thing that might make the seller give you more time? How about if we give them more money? Money talks, yes? So that could be part of our negotiations. Look, we need another week. So how about I give you an additional X amount for due diligence? It's all part of those negotiations. Buyer's failure to deliver, let's see, failure to deliver a termination notice prior to the expiration of the due diligence period will constitute a waiver by the buyer for any right to terminate. Provided, however, following the due diligence, buyer may still exercise the right to terminate if the seller does not comply with the obligation. So once we're out of due diligence, if the buyer terminates for any reason, they are in breach. They will lose their due diligence fee still, and now they're going to lose their earnest money deposit. So another explanation, another way to help us understand that due diligence process. And then the rest of this in this section is going over the things that the buyer should consider doing during their due diligence. We're not leaving them high and dry. We're not going to say go investigate the property and then let them figure out what it is they need to do. We're going to walk them through as a buyer's agent. We're going to walk them through these things that they should consider doing during their due diligence period. And the first thing that the buyer needs to do now that we're under contract, they need to get going on that loan process. I'm telling you right now, the loan process is the longest part of the contract to closing process. So buyer's agents, like the moment you go under contract, do your little mini celebration. But the moment you go under contract, we need to be sending that executed contract to the lender so they can start. That's when they actually start their process, getting that final loan approval. That whole process will come next week when we look at our mortgage lender units 14 and 15. The other thing I want you guys to see here is that our contract tells us that there is no loan or appraisal contingency in this offer. If the parties agree to a contingency, it's going to tell us later, if the parties agree to this contingency or any contingency, then we need an attorney to draft this up. I don't have a pre-printed form, and the contract actually spells out. So in other words, what we're saying, you guys, if we don't have loan approval while we're still in due diligence, final loan approval while we're still in due diligence, if we find out after due diligence that this loan isn't going to get approved, the buyer has to terminate and they're in breach. When we say they terminate for any reason after due diligence period, that could also include loan approval. Things in the property investigations, we want them to do any inspections. I'm going to spend more time talking about the property investigation when we go through the contract to closing process in Unit 21. So just briefly, the buyer should be encouraged to have a home inspection. They should be encouraged to have a pest inspection. Maybe they want the radon level tested, you know, various things. If it was built prior to 78, maybe they want to have the paint tested for lead, etc. Review of documents, specifically if it's in an HOA, we're encouraging the buyer to review those covenants and all the documents that go along with the HOA so they know the rules going into it. Homeowners insurance, if there's a lender involved, homeowners insurance is required, period, end of story. If it's a cash buyer, homeowners insurance is highly recommended. But if there's a lender involved, we have to get a homeowner's insurance secured during due diligence. Also, if there's a lender involved, the lender will require an appraisal. They want an appraisal to come in, they require it, but they let the buyer pay for it. More on all this to come. There's our survey to help us identify the parameter, the lines of the property. Investigate learning more on any zoning, governmental regulations, and governmental compliances over zoning. You can see there any law, ordinance, permit, government regulations, school zones. Again, when we say the buyer is trying to learn as much about the property as they possibly can, this is their time. And these are suggestions on things that they should consider learning more about. Is it in a flood zone? Is it in a water hazard? What are the utilities? Who's going to be your utility provider, your internet provider? Streets, are they public or private? Some lenders want to know if they are private streets, if the homeowners have to maintain that. And then any special assessments. So all of this falls under the property investigation. Again, we're going to get into a little bit more detail, not a lot, but a little bit more detail in 21, kind of going through that process, that due diligence process. Understand that this list of property investigations, this is not an all-inclusive list. This is just to help to get the buyer started. This gives them an idea of where to start. Remember, you guys, I'm not the one buying this house. I'm not the one taking on a 30-year mortgage. If my buyer wants to inspect or investigate something that's not on this list, then we're going to do it. Because if it's important to them, then it's important to me. Never look at your buyer and say, oh, you don't have to worry about lead. I'm sure it's fine. No, never ever look at your buyer and say that. If they say, I really want to have this inspected, even if it's not on this list, I really want to have this inspected. Our answer is, okie doke, let's do it. Because it's important to them, so it becomes important to me. Other things the buyer should consider doing during their due diligence. If they have to sell or lease an existing property, I'm not creating a contingency here. I'm just letting the buyer know. If you have to buy or lease, let me try that again. If you have to sell or lease another property in order to buy mine, then the buyer should try to have it closed while we're in due diligence, or be reasonably assured that it's going to happen. I'm not creating contingency. I'm just letting the buyer know we need to have this done. We need to have this finalized. And if we do it while we're in due diligence, if the buyer doesn't buy, then they can still get out and we can get their earnest money back. After due diligence, if they don't buy, they have to terminate, and now they're losing that earnest money. Repair improvement negotiations and agreements. Buyer acknowledges and understands the following. One of the more important sentences in this contract. Unless the parties agree otherwise, the property is being sold in its current condition. Aren't we just saying as is? Homes in North Carolina are as is. The seller is under no obligation to do any repairs. We can always ask. The worst they can say is no. If the seller agrees to do any repairs, the repairs have to be agreed on, in writing, and signed while we're still in due diligence. If the seller's going to do anything, change a light bulb, we have to have it agreed on, in writing, and signed while we're in due diligence. We have to have the seller's commitment. The repairs themselves don't have to be complete until prior to settlement. But we've got to get that agreement in writing while we're in due diligence. Again, understanding that the seller is under no obligation to do repairs. Buyer's agents, make sure your buyers understand that. They expect in some cases the sellers to do repairs. And we could possibly be setting them up for disappointment if we say things like, oh yeah, I'm sure the seller will fix that. The seller doesn't have to do anything. We can ask for repairs. After our investigations, we've learned about the property. We can ask for repairs, but we need to prepare our buyers for the sellers to say no, or for the sellers to say, I won't fix all of that, I'll fix some of it. Maybe the seller will agree to do it all. We are in round two of negotiations. Repairs are always considered round two. But this sentence is just reminding us that the seller's not obligated. They don't have to do anything because this property is being sold in its current condition. Comments on that? Buyer's obligation to repair damage. I gave the example earlier. If the buyer's home inspection damages the property during the inspection, the buyer's on the hook for it. The buyer and all the people that the buyer hired, all the people that the buyer bring on to do their investigations, the buyer's responsible for them. So remember, we've talked about always giving your buyer several different recommendations. I doubt they know a home inspector, So there's a good chance they're looking at you going, who do you suggest I use for a home inspector? Be very careful about saying we're just going to use this home inspector, that you have no choice. Instead, give them choices. Here's 2 or 3 home inspectors I've used in the past that I've had a good experience with. Or here's a couple that my firm has used, maybe because you're new and you don't have anybody yet. You'll form that village, you'll form that group that'll help you, your close contacts. But the buyer's obligation to repair any damage by anybody they hire to do their investigations, the buyer's on the hook for any damage caused. Even if the buyer terminates, this repair obligation shall survive any termination. The seller has the right to have their house fixed if the buyer terminates. Then we have the buyer's right to terminate. Again, back to our due diligence. Buyer shall have the right to terminate this contract. Here it is again, for any reason or no reason. All they have to do is provide written notice of termination to the seller. They don't even have to tell the seller why they're terminating. All they have to do is provide in writing the fact that they are terminating. During the due diligence period, and we're reminded that that is a time is of the essence. If the buyer timely delivers that notice, the contract shall be terminated and the earnest money deposit shall be refunded to the buyer. If we're terminating for any reason during due diligence, the buyer will get their earnest money back. The last thing here then says closing, all bold in caps, closing shall constitute acceptance of this property in its then existing condition unless provision is otherwise made in writing. Congratulations, Mr. and Mrs. Buyer. This house and all of its problems are yours. Here are the keys. And by this point, if they did their inspections, if they did their investigations, they know. It's just a matter of whether or not they agree to take it. No home is perfect, you guys. There's no property out there that doesn't have issues, that doesn't have problems, even brand new construction. Humans built it, humans make mistakes. The question is the buyer willing to accept the property with these conditions, with these things that are wrong with it? And once they do, remember, closing is the recordation of that new deed. So once they do, there's no takebacks, there's no return policy. Once that deed records, it's a done deal. What do we think about the buyer's due diligence process? It's a very good tool to help us as buyer's agents introduce the buyers to the things that they should consider doing. I can't make anybody do anything, but this is what I think you should consider doing, so you can decide if you want to proceed with or terminate this transaction. What do we think? So now we're at provision 5. Provision 5 is all about buyer representations. These are things that the buyer is representing to the seller, that the seller should be able to rely on for accuracy when deciding if they want to enter into a contract with this buyer or not. And what's the first thing that the seller cares about? Does the buyer have the funds to complete? Do they have the money, or can they get the money? That's the buyer's big thing, to come up with the money. So how are you going to pay for that? How are you going to buy this property? So we got some options. Maybe this is a cash buyer. They don't have to get a loan. They don't have to get any loan assistance. They're going to buy this home in cash, or they have to get a loan. They have to have some of that sales price handled in the proceeds of the loan. So we're just representing to the seller how we intend to purchase. Specifics, a little bit of specifics about the loan, more blanks to fill in. The buyer also has to represent to the seller they do or do not have to sell or lease another property. Again, I'm not creating a contingency. I'm just representing to the seller I do or do not have to sell or lease another property in order to buy your property. If the buyer has to sell or lease, then we have to complete this section. Buyer's other property is under contract, or buyer's other property is not under contract. Maybe it's currently active for sale. Maybe it's not even on the market yet. All we're doing is representing to the seller that this is I can't buy your home. I'm not creating a contingency, but I'm letting them know I have to do this first. We have a note reminding us that this is not conditional. This is not a contingency. If we do create that contingency, then an appropriate contingency addendum should be drafted by our attorney. I do not have a pre-printed form for this contingency. So if you find yourself in the situation, then we have to contact your buyer's closing attorney to have them draft up that contingency for us. The buyer has to represent whether they have or have not received the RPODS, Residential Property and Owner Association Disclosure Statement. And then we're going to go through this again. They have or have not received the MOG. So if they have received the RPODS, then we're going to check this box at the time that this offer is made. If they have not received it, then this paragraph goes on to talk about the buyer's right to terminate. So they have that end of that third calendar day that we looked at, or the end of the third calendar day following the effective date. What this is saying is within this time frame, within this timeline, if the buyer has not received the RPODS, then they can terminate. And if they terminate because they haven't received the RPODS, they will get their due diligence fee and their earnest money back. This is another example of when the buyer may get their due diligence fee back. And that is if the seller fails to provide the RPODS. And obviously, we're still in due diligence. We're only 3 days in. So we're still probably in due diligence, in which case they will also get their earnest money back. And then we go through that same little exercise with the MOG. The buyer has either received it or they have not received it, in which case these are the consequences. Again, if the seller doesn't provide it, not only could it be an out for the buyer, but it could make the seller return that due diligence fee. I bet you that'll get them signing that disclosure if they haven't already. You could lose your money. Okay, so buyer representations, any questions on those comments? Again, when the seller looks at this, especially multiple offer situation, the seller's trying to decipher which buyer to take. And so they should be able to look at this representation section as completed accurately, and they should be able to trust that this information is correct. Miss Lynn, did I see your?
Yes. So the number 5, the residential, the disclosure we were talking about, the R codes, that is that lists the year, all the issues wrong with it. That's the document. Okay.
Yep, that's our seller disclosures. Yep. Thank you. Anything else on our buyer representations? take a break. We come back. We keep going. Offer to purchase and contract. Like I said, before we leave here today, we got to talk about what next week looks like. So we'll certainly allow time for that. So let's take 10. And we're back. Cameras are coming on. And I can see you. I can't see you. I can't give you credit for this hour if I don't hear from you in the chat. Rules. All right. So I am taking attendance, and guys, listen, I see you out there. I understand forms are not the most exciting things in real estate, but you know what we deal a lot with in real estate? Forms. So it's just the beginning, you guys. There's an old saying that there's a form for everything. And as a broker assisting buyers and sellers, I gotta be familiar with the forms. So we're just kind of getting you started. Fair enough? Just easing you in. Like I said, I know it's not the most exciting thing. It's not the most glamorous part of real estate, but it's such a big piece of it. So with that being said, back to forms. So we talked about the buyer's due diligence. We've talked about the buyer's representations. 6 then is about the buyer's obligations. These are the things that the buyer is expected to do as part of their due diligence or part of their contract to closing process. Again, failure to complete any of the obligations may result in breach. So buyer obligation, we've already defined special assessment. So now we have to talk about what the buyer's responsibility for any of these special assessments are. The buyer's responsibility for special assessment. The buyer's going to take subject to all special assessments that are approved after settlement. So anything approved before settlement, we're going to learn following settlement. Anything approved before settlement, we're going to learn is the seller's responsibility. Anything approved after settlement will be the buyer's. A good rule of thumb with special assessment: whomever owns the property when the special assessment is approved is the one that's responsible for it. There may be special assessments pending special assessments, those on the tables for discussion that haven't voted yet. The seller should let the buyer know about that so they know coming into it that there may be a special assessment approved following settlement. We'll see those seller obligations in just a second. Buyer's obligations are going to be responsible for certain costs. So any costs associated with their loan, any charges by the owners association, there's usually an admin fee from the owners association, the HOA, to transfer from this owner to that owner when that property conveys. Contract would include anything with inspections, investigations, appraisal, title search, etc. So unless agreed otherwise, again, we're getting closer to talking about the buyer's closing costs and the monies that they owe for settlement. So this helps us start to understand what their responsibility is. And then authorization to disclose. There's other people that need access to the contract in order for them to do what they have to do to process this contract to closing. The lender will need the contract, the executed contract, in order to process the loan. The closing attorney will need a copy of the contract in order for them to do their thing. What this is doing is it's giving authorization for us to give that information. If the appraiser needs it to do their job, then we have permission for them to do it. Whomever needs it in order to get us to closing has permission to get that information. Again, 4, 5, and 6 are all about the buyers. So my buyers agents out there, we talked about how we're going to help our parties understand the terms of the contract. So if you're working with buyers, these are the sections that are specific to those buyers: 4, 5, and 6. Questions? Make a note. If 4, 5, and 6 are all about the buyers, then 7 and 8 are all about the sellers. So listing agents, when the seller wants to know what about this contract is for me, talking to sellers, we're going to look at 7 and 8. So first off, we have seller representations, what information they share with the buyer that the buyer should be able to rely on for accuracy when deciding if they want to enter into the contract with this buyer. First thing the seller has to represent is how long they've owned the property. Some lenders care about this. Remember my earlier example with my investor in the FHA and he had to own it for 90 days? Some lenders care about how long the seller has owned the property before they go to sell it. So the seller has to represent their ownership. If the property was built prior to 1978, then the seller has to represent any known presence of lead in the home. And again, we're reminded, if that is the case, then we're going to attach that lead-based paint or lead-based paint hazard addenda. So using the forms to help us know what additional documents we may need. Any information about the owners association and dues. So here's where the seller is going to provide the buyer the covenants, articles of incorporation, bylaws. Are there any special assessment proposed special assessments out there? By the way, this exact same list, this exact same verbiage also shows up in our listing agreement. So we can have this conversation, listing agents, with the sellers at the time of listing and say, when we get a buyer, they're going to ask for this information. They're going to want this information about the HOA. So let's go ahead and gather it now. So when we have the buyer, we can provide it to them for them to review as part of their due diligence. The seller's also going to tell us the name of the association and what the dues are. They're usually X amount per month, per quarter, per year, however the HOA issues those dues, the current dues, whatever those are. And we have a place here for 2 different HOAs because some places have more than one. Some places may have like the mandatory HOA to take care of the common grounds, and then they may have an optional HOA for the pool, for example. So all we're doing is just representing the information to that buyer so they know what they're getting themselves into. Fuel tanks. If there's a fuel tank on the property, then the seller has to represent what they know about the fuel tank. To the best of the seller's knowledge, there is or is not a fuel tank. If we said yes, we're instructed to complete the following. And you can see we're going to describe the tank. And I got a place here for 2 tanks. So it currently is in use or not in use. It's owned or leased. Where is it located? Above ground, below ground? What's in it? Is there oil in there? Is there propane in there? And then the name and contact information of the fuel vendor who provides the fuel, passing that along to the buyer. Then we're told that the tank is included in the sale. Buyer and seller agree that any tank described above shall be included. Seller can use the fuel in the tank through settlement, but otherwise, whatever's left is going to stay for the buyer. They can't try to take fuel with them. One of these notes here is telling us that it's against state law to try to remove fuel from a tank. So the seller needs to understand that what is left in the tank when we close is going to remain for the buyer. They can't try to drain it. They can't try to take it out. Somebody asked earlier if buyers and sellers ever go to court. Fuel tanks have put them in court on numerous occasions. And I'll be honest, this section in our contract has recently been revamped to try to prevent all these buyers and sellers going to court over fuel. So this verbiage now hopefully tries to address that, makes it very clear so everybody knows what they're getting, what they should be getting. And then any leases. The seller has to represent to the buyer that there is or is not, the property is or is not subject to any leases. If it is subject to a lease, then we have a couple additional, we got additional provisions, addendum, vacation rental addendum. We're going to briefly discuss those. Bottom line, in North Carolina, if a buyer buys a property that has an existing lease and tenant in place, then they buy honoring that existing lease. So if you're going to buy a property with a tenant, you're going to get that tenant. It's going to be an assignment. All the terms will stay the same. The only thing that changes is the names of one of the parties. And in this case, that party will be the landlord. The landlord will change from the seller to the buyer. Closing attorneys will assist with that paperwork. But one thing the seller needs to do is provide the buyer with the current lease, the current tenant's financial obligation. Are they up to date on rent? Or are they behind? This kind of takes us back to the whole idea that a buyer deserves to know what they're buying. And that includes if they're going to acquire a tenant. So we want the seller to provide that all information during due diligence for them to take that into consideration. Questions on our seller representations? Then we have seller obligations. Again, what are the seller's obligations in this contract? They've got to show evidence of title. They got to prove, they may have to prove that it's their deed. The attorney will pull the deed. The attorney will do that title inspection and investigation that we talked about in Unit 5. They're going to make sure that the chain of conveyances links, that the deed links match up from grantor on this deed to grantee on the previous deed. If there's any kinks in the chain, or if there's any issues with the title, the closing attorney will get with the seller and address that, correct it before settlement. The seller can't convey with kinks in the title. They can't convey with issues. So the closing attorney, if any are found, the closing attorney will get with the seller to clear those up. The other thing that the seller will have to provide to the closing attorney is any outstanding mortgages, balances, that kind of thing. Because the lender, the mortgage company, will calculate the seller's amount due. They will calculate that to the day of closing, including interest up until that day. So we got to get, the attorney will have to gather who the seller's lender is so they can communicate with them to get that payoff amount. So the seller can pay that off and disclose. Authorization to disclose information. Again, we saw this in the buyer. This just gives anybody permission that needs access to certain documents so they can do their thing so the seller can sell. They have that permission to do so. Access to the property. Seller's going to provide reasonable access to the property through the earlier of closing or possession by the buyer. We might do like an early possession, for example. We'll talk about that. What we need to understand with this, now that we're under contract, the seller has to provide reasonable access to the property for the buyer and their inspectors to come on the property and do their inspections and investigations. The seller can't deny the home inspector coming on their property. They can't not allow the appraiser. The buyer has that right to do those inspections and investigations, and the seller can't deny, again, reasonable access, understanding they very well might still be living there, but that reasonable access, they can't deny the buyer from doing their due diligence, from doing their inspections and investigations. The other thing, seller's obligation includes providing existing utilities operating at the seller's cost. So we go under contract, even if the home is vacant, the seller's got to keep the power, keep the water, keep the utilities going to the home so the buyer can do their inspections. The home inspector can't inspect the AC unit if we don't have power. So they're going to keep those utilities going for us. Removal of seller's property. They have to remove everything by the date possession is made available to the buyer. Generally, we need it vacant by the time we go to settlement. We're going to talk about something called the final walkthrough. And the final walkthrough is the buyer's opportunity to see the property one more time before they go to the attorney's office and sign. Because remember what we said, that closing constitutes acceptance of the property in its then current condition. So if we don't do the final walkthrough, the buyer doesn't know what they're signing. We want to make sure that all the seller stuff is out. If we negotiated any personal property, we want to make sure that it's there. Sometimes we do the final walkthrough and we find a bunch of garbage or debris. Sometimes the sellers think they're leaving the buyers a gift. What they're saying is, I don't feel like moving this, so I'm just going to leave it here for the buyer. I think one of the more common things that comes up with that is the grill. I don't know why, but the seller's like, I don't want to move the grill, so I'm going to leave it. Well, guys, if your buyer wanted the grill, they would have asked for it with the offer. They didn't, it's not negotiable, so the seller has to remove it. Question comes up, what if? What if we're doing the final walkthrough and we see a bunch of garbage and a bunch of gifts, like the grill or other things that we didn't negotiate? Your buyer at this point has two choices. They either go on to the attorney's office and sign and accept it how it is, or they don't. We need to understand that if they sign, they accept. They can't sign and then later address it. We need to address it before they sign. We're on our way to the attorney's office. We're probably going to meet at least the listing agent, maybe the seller there too. We can, kind of renegotiate, rehash these things out. But buyer's agents, we need to make very clear that your buyers understand. Don't sign it and then think we're going to address it. We address it and then sign it. Does that make sense? And the reason why, I'm going to go back for 1 second. And the reason why is because of this very important bolded sentence that says, closing shall constitute acceptance of the property in its then existing condition. Once they sign, they agree to take it. I had buyers once. She's a really good friend of mine. I don't know why that's important to the story, but I feel like it is. Very good friend of mine. Her and I were doing the final walkthrough. She poked her head in the attic. It was one of those pull down stairs, that kind of unfold down on each other. She poked her head up in the attic and it was still jam packed full of stuff. The rest of the house was vacant, but the attic hadn't been touched. I called the listing agent. I said, what's up with the stuff in the attic? She said, it's not my guy's stuff. So whose stuff is it? And I asked my buyer, I asked my girlfriend, I'm like, look, they don't want it. Apparently, come to find out, funny story, come to find out the stuff in the attic was the previous owner's stuff. Those people in the 7 years they lived in that house never once popped their head in the attic and said, wow, there's stuff up there. It was brand new information. Poke your head in the attic every once in a while, you guys. I know it's not the best place, but poke your head in the attic. So anyway, I asked my buyer, I asked my girlfriend, I said, you want the stuff? And she was like, no, I got enough of my own stuff. I don't want somebody else's stuff. Called the listing agent back and said, we got to get it out or we're not going to sign. Because had we assigned, that stuff would have become her stuff. It's like, I don't know, there might be treasures up there. You never know. And she was like, nope, got enough of my own junk. I said, hey, I hear you. But we got to do that final walkthrough because the buyers need to know what it is that they are accepting. And if there's any issues, I mean, let's say you've never seen this home vacant before. You've only seen it occupied. The sellers just moved out last weekend. And they take this picture down and we learn in the final walkthrough that the only reason this picture was here is because there was a big hole punched in the wall. Your buyer's got a choice to make. They either sign and accept this wall with the hole in it, or we go to the attorney's office and get it addressed before they sign. Comments on that? Other good stuff. Good title, legal access. Seller shall execute and deliver a general warranty deed. Convey fee simple, marketable, insurable title without exceptions for mechanics liens, easements, utilities, encumbrances, encroachments, etc., ad valorem taxes. We actually, you guys are ahead of the game. We saw this paragraph back in Unit 5 when we were trying to figure out why we were spending all the time talking about what we're talking about. The reason we were was to build us up to understanding the sales contract, understanding the seller's obligations, and understanding what they are required to do, that good title legal access. So those words now make more sense to us than what they did. And helping sellers understand that that's their big obligation. They got to provide that general warranty deed, that clear marketable title. Agreement to pay buyer's expenses. One point of negotiations is the seller may agree to pay some of the buyer's closing costs. So if the seller is going to agree to pay anything for the buyer towards settlement, this is where we agree to it. And this is another one of those, this is a dollar sign. So if the seller says, no, I'm not paying anything, make sure we put a 0 in there to indicate that, to show that. Don't leave that blank open and let the buyer come in and give themselves some money that the seller may not catch. So back to not leaving a blank. Here's our special assessment. Seller's going to pay in full at settlement all special assessments that are approved prior to settlement. So anything that has been voted aye before settlement is the seller's responsibility. All special assessments voted yes after is going to be the buyer's responsibility. Again, just a really good rule of thumb. Whomever the owner is when the special assessment is approved is the one that's responsible for it. Seller's going to pay any late property taxes. If they never pay 2023 taxes, those are going to be their responsibility at settlement. We will share this year's taxes, but any delinquent taxes will be the buyer's or seller's responsibility. Negotiated repairs. If the seller agrees to do any repairs, they need to be done in a good and workmanlike manner. And buyer always has the right to verify those repairs or improvements prior to settlement. So if the buyer wants their inspector to come back or their electrician or whomever to come back and verify those repairs. You may also want to consider not all sellers are handy. Not all homeowners know what they're doing with a hammer. I mean, we all have a YouTube video, right? Does that make us know what we're doing? So you may want to put verbiage in there, you know, for your buyer, like electrical work to be completed by a certified electrician, for example, instead of letting the seller handle it. So some repairs we may want to request that the professional does it. Others we might be okay with the seller doing it. Just depends on the buyer. Whether or not we're going to negotiate a home warranty. Again, another negotiable point. The seller may or may not provide a home warranty. All points are negotiable. And then seller breach. I got a whole paragraph at the end for seller breach. So paragraph 23 splits what happens if the buyer breaches, what happens if the seller breaches. So we'll see that there. Questions about 7 or 8 are sellers' representations or sellers' obligations. Charges by the owners association. There's going to be fees by the HOA if we have an HOA. Some admin fees from changing from one owner to the next. So this section just spells out what the seller's responsibility to pay for those owners association charges, what the buyer's responsibility is. Prorations and adjustments, there are certain items that are going to be prorated at closing. If we're prorating, we're taking a shared expense and we're making it fair. So one example could be this year's property taxes. Neither one of us should have to